And can we start? Good morning, participants. Dr. Manohar, Lohiya, National Law University, Lucknow, welcomes you on the fourth day of Master Class. Today we are present again with another eminent speaker on the subject of corporate restructuring. I'm sure with his vast experience of over 2 decades, corporate restructuring will be benefited. Salakshi, Dr. Manohar, National Law University, who is a program director and designed this program to bridge the gap between the academia and the industry. I welcome you, ma'am. Today we have privilege of having Ms. Cheryl Mehta from National Law University, Ranchi. Welcome you, ma'am, to this unique master class. Let me introduce the Ms. Mehta first. Then we will introduce the today's speaker. Ms. Cheryl Mehta is a professor at National Law University, Ranchi. She is a 5-year law graduate from University of Mumbai. She has completed her post-graduations in law from Symbiosis Law College, Pune. Her areas of interest are business laws, including corporate laws and environmental laws. She is currently pursuing her PhD in regulations in forest land in the state of Jharkhand. I have just been informed in the morning that she has got her doctorate completed recently, and now she is Dr. Cheryl Mehta. Many congratulations to you, ma'am. Its social, economic, environmental impact on which she has done the doctorate. She is the chairperson of the Moot Court Committee of NUSRL and has successfully conducted more than 3 national level moot court competitions. Welcome you, ma'am. Now I will request Dr. Vishalakshi, ma'am, to welcome our speaker and also Dr. Cheryl Mehta. We can proceed forward. Over to you, Dr. Vishalakshi. I believe there is some technical issue. She is not able to respond. May I request Cheryl Mehta, ma'am, to kindly introduce the today's theme.
Sure. Good morning, everyone. Very grateful to RML NLU for giving me this opportunity to Mr. Amit Gupta, to Dr. Visalakshi ma'am. Thank you very much, and I'm really honored for this opportunity. Now, today's topic, corporate restructuring. As far as corporate restructuring is concerned, there are many different terms that we use for corporate restructuring, which commonly you must have heard for it known as capital restructuring, business restructuring, or mergers, acquisitions, takeovers. Now, there are two types of growth strategies: organic growth strategies and inorganic growth strategies. So particularly, we'll be looking at inorganic growth strategies. If you look at inorganic growth strategies, they're fast-track corporate restructuring strategies. That is like we're talking about mergers and acquisitions. The inorganic growth strategies is they are considered fast track because they allow companies a speedier mode of entering new markets, cutting competition, etc. So that itself allows the company to restructure itself, reorganize itself, and corporate restructuring is basically a procedure which changes the organization of business, and such reorganization may require either an integration or disintegration of business. So, a very famous case, I think we all must have heard about Cadbury UK being acquired by Kraft Foods USA. And then later on, it was split into Mondelez International. So, the very famous Cadbury that we now eat actually doesn't belong to Cadbury UK anymore. In fact, Cadbury UK has been absorbed into Mycraft, and then later on, a separate company known as Mondelez International was formed so that the entire confectionery business was transferred into it because it had become an obese company. It had multiple you can say businesses. It had cheese business, it had frozen foods business, and the company was unable to run because it has slow moving products as well as fast moving products. So under such circumstances it is best advised to split the business so that the business can do well. So, restructuring doesn't only mean that two companies will be merged or amalgamated. It may also be split or spin off. Basically, let's take a look into the popular formats of inorganic growth. That is, one is merger. Now, if we before looking into it, the new companies Section 232 allows amalgamation and reconstruction. So basically, merger is a combination of two or more companies which can be merged together either by way of amalgamation or absorption or by formation of new companies. So there are three formula that we can apply here. One is A plus B is A plus B is B, and then A plus B is C. So where we talk A being a larger company, so where A and B companies merge, B company gets shares of A company on a ratio basis, and the result is that only A company remains and B company is dissolved. Similarly, A plus B is equal to C is also a very common phenomenon where two companies come together and they form a third entity. Okay, but A plus B is equal to B is rare. Okay, where sometimes it is termed as a reverse merger. Now, reverse merger happens basically whereas either a small company merges into a big company and the resultant company is the small company, or where a loss making entity merges into a profit making entity and the resultant entity name, it may either be the loss making entity's name or the profit making entity's name, but more so it is the loss making entity's name which actually makes call it a reverse merger. So a classic example of reverse merger is where in 2002 ICICI Limited merged with ICICI Bank Limited. It's a banking arm, and ICICI Bank Limited was very small. Like the ICICI Limited was a huge company, had about three times the uh, structure of ICICI Bank. But then what is the result? It's the ICICI Bank Limited. So after merging, ICICI Bank Limited, which was the smaller company. And this may be done for various reasons, like there are certain licenses which are available to the subsidiary or small company, and which is not available to the larger company or the holding company. So to continue with that, or there may be several reasons, tax avoidance. It also can help making the books opaque. So under such circumstances, reverse mergers also take place. Other words usually known as plain vanilla mergers or forward mergers. So that is also one reason that reverse merger takes place. Then there are certain other reasons also. Sometimes what happens is that shell companies are there, companies which were operating, but they stop operating, but they're still traded on public platforms like the stock exchanges. So now a private company wants to go public, but will have to undergo such a huge procedure. So the shortcut is that that's why fast track restructuring process. So they merge with a company which is already on the public platform but not doing business. They merge with them, get majority shares of that particular public company, and this also is a reverse merger. Another is where company specially floated in the public platform, that on a in a later stage they will get eventually merged with a larger company, which is maybe a private company, who will get a public trading platform because it is merging with this particular company who is newly formed for these purposes, for the purposes of reverse merger. Such companies are usually known as clean companies. Then there are various types of mergers. Horizontal merger, for example, is a merger where two companies having similar products, having the same market, are merged. So a very good example of that is Lipton Tea and Brook Bond Tea when they merged. Okay, so now it is Lipton Brook Bond. So we have the third type of merger: A plus B is equal to C, forming a new company. And then we have vertical mergers. For example, a company having similar products, which are useful for each other. I'll give you an example. Although it's not a merger, it's a joint venture. But if we look at Maruti and Suzuki, one company makes the body, the other company makes the engine. If such companies merge together, the merger will be a vertical merger. Then we have a conglomerate merger, companies totally unrelated products when they are merging together. So, for example, L&T and Voltas Limited merged. They are totally different companies, dealing in different products, having a different market, having different customer base. So, such mergers are vertical mergers. Then we have con-generic mergers, where the products are similar, but they may have similar database. The products are similar, but they are not like products. Okay, so like these products, they may have the same industry, but they are not the same products. They are not competing products. So such products when they merge, or such industries when they merge, it is known as conjunct merger. And then what we know is something commonly known as demerger, which is also provided under Section 230, which was earlier not a part of the 1956 Act. Now, this is basically where a company split. So there may be two things: either it may be a split off, or it a spin off. Now, the difference between the two are that a split off is basically where a separate company is formed altogether. And in spin-off, what happens is a separate company is formed, but the same shareholders in the same ratio are giving the shares of the other company also. So a company is split two companies. And then how restructuring may happen? It may happen by disinvesting or divestiture. It is basically selling a particular business away, or selling a subsidiary to another company or another person. So these are types of business restructuring. We also have another common inorganic growth strategy, which is a fast track one, known as takeover. So basically, where you acquire a substantial amount of shares of a company so as to effect a change in the control of the target company. Such a particular sale of shares, which is so substantial in nature, will be termed as a takeover. For a regulating takeover, we have a separate code known as the takeover code, or the SEBI substantial acquisition of shares and takeovers, which is, in effect, which actually guides you how takeovers go through. Then we may have certain types of takeovers: a friendly or a negotiated takeover, where two companies actually enter into negotiation, or an individual with a company or persons acting in concert. They may enter into negotiations with the company to buy a substantial amount of shares of the company, and the company may agree. Like right now, Jet Airways is in a very bad position, and then time and again we're expecting Mr. Naresh Goyal to shred his shareholding, even as a part of the restructuring plan, so that he will dilute his shareholding and hand over a substantial amount of shares to another person who is willing to invest in the company, so that the debts of the company are paid off. But he is not willing to do that because that will effect a control change. Okay, his control of the company will be diluted. So such substantial acquisitions are governed by takeover code. They're friendly or negotiable. takeovers. But there may be a hostile takeover also, where a person tries to acquire the shares without the consent of the board of the company. And in fact, initially when Cadbury shares were being purchased by Kraft Foods, it was considered to be a hostile takeover, because Cadbury was not willing to being taken over by any other company. However, at the end, the shareholders agreed to sell the shares, completely. They sold all their shares to Kraft Foods. So then it was negotiated. Then let's come to financial restructuring, which is a little more complicated. Now, as far as financial restructuring is concerned, it can be for various reasons, like you want to improve your financial performance, you want to cut competition, or there may be other various reasons. Your liabilities are more, you are unable to pay your debts, or you have certain financial issues. So these type of things are where financial restructuring takes place, and there are two types basically. One is debt restructuring and the other is equity restructuring. Now, in case of restructuring and mergers basically, or any scheme of arrangement or compromise which is there under 232 233, okay, sorry, 230, and such a scheme of arrangement or compromise where you want to enter into a compromise with either your members or with your creditors. There may be debenture holders or there may be other creditors. Then you need to approach the national company or tribunal with an arrangement or a scheme. And the scheme should mention as to what you want to restructure. You want to restructure your debt, you want to restructure your equity, or whether you want to go for an amalgamation, or whether you want to go for absorption. And what is the scheme? What is the proposed, shredding of shareholdings, sale of shareholdings, how shareholdings will be distributed, which company will be dissolved, what about its employees, etc., etc. You need consent of the members, consent of the creditors. You need to file, a declaration that the company is a going concern. So all these things, they are presented before the NCLT. Earlier it was before the High Court, and now it's before the NCLT, that is National Company Law Tribunal. And then the tribunal ask you to convene certain meetings and require certain resolutions to be passed. And if they are all in order, then it has the discretion. Section 230 to 236, they give the power to the tribunal to either allow a merger, maybe with certain conditions, or it may also reject, even if it's all fine, because it doesn't actually go into the business sense of the merger, but it only looks at whether it is a valid merger or not, whether the procedure has been properly followed, and if there is anything which is unfair and being objected to, then it looks into those objections. But there is another shortcut also that the 2013 Act provides under Section 233, which is at times known as the fast track merger. Because see, when you want to go for when you want to go for a merger, there is a compulsory court intervention. Even if there are two willing parties, you will have to go to court and apply to court. Both the companies will have to file the forms. The companies will have to go through the procedure of convening the meetings, and once all this procedure is done, only after that the court allow or maybe reject. But sometimes you don't have so much of time, or you don't really need so much of intervention. So section 33, read with rule 25 of the Companies Compromises, Arrangements and Amalgamations Rules 2016, they provide for a fast track merger. Basically, there are certain classes of companies which can merge without going to court. For example, small companies. If you look at the definition of small companies, you must look at section 2, subsection 85 of the Companies Act 2013, which will give you a definition of small companies, or where a holding company wants to merge with its wholly owned subsidiary or fully owned subsidiary. So it owns all the shares of that particular subsidiary. Then it doesn't need to go to court. But if it's a partly owned subsidiary, you will have the court's intervention. Then restructuring also has a new route now, which is under the Insolvency and Bankruptcy Code. Now, Section 230, as I told you, provides for schemes of compromises, arrangements, basically amalgamations, mergers. And earlier, the view of the National Law Tribunal was that when you are coming through IBC proceedings, okay, it only means that we have to either dissolve the company or restructure the company, but we cannot have restructuring through mergers or acquisitions or takeovers. However, this view has been changed by NCL80, that is the Appellate Tribunal, recently, and it has said that reorganization procedures under Section 230 are also applicable to the insolvency processes initiated under the code. And that is how we can also have debt restructuring, and of course debt restructuring through IBC is also possible, where again a company is allowed to take over. In fact, that is also the case with Jet Airways that we were just discussing. So I think that we have multiple routes now and a lot of options where a company need not only be dissolved or declared unable to pay its debts, but rather it can come up in a new form, in a new avatar, and it can do where it need not be dissolved, or you can say that the shareholders may just not lose money. It may also be a situation where it can be revived. So for the purposes of revival or competition, restructuring is the go-to option, I would say. I think I should end it here because we have our panelist who's going to give you more details on it. Right? I hope this is fine, sir. I haven't taken much of your time.
Wow, it's excellent setting of a tone for the session for today. I'm sure the talks that you have made, the canvas that you have drawn for the today's discussion will be very fruitful and will be helpful to our eminent speaker, Krishna Mishra ji, also to organize his thoughts and cover all these aspects, whatever Hiral Mehta ma'am has stated. I will just introduce he's from Chennai. He is a member of the Institute of Communications of India and a graduate of law. He is also a registered trademark attorney with the Trademark Registry India. He has the bachelor degree in economics with the honors from Delhi University. He has experience of almost 2 decades in handling various issues in regard to the trademark management, joint venture, corporate restructuring, formation of companies, trust, and various other related corporate matters. He has worked with the organization like Polaris Software, Murugappa Group, Taj Group of companies, and several other listed and unlisted companies. He is a regular visiting faculty on the company law, and he is also a trainer in the in-house training academy at Chennai, which is run by one of the big four consultancy firm. He is also invited regularly by the Institute of Company Secretaries, Chartered Accountant, and several other management graduate institute. He has interest in freelance writing with article published on the Business Line and a reputed law journal, Consolidated Commercial Digest, Chennai. He has also extensively assisted the co-author, Mr. N.R. Sridharan and Mr. Arvind Pandian on the Guide to Takeover and Mergers, published by LexisNexis in the third edition of the book. This session on the corporate restructuring. Now we have Dr. Mishra. I will just request ma'am to say welcome to and let the session begin.
of young minds. And thanks a lot. Morning time here. Namaste.
Good morning, all. First of all, thank you for the kind introduction.
Go ahead.
Yes, thank you, CS Amit ji, for your kind introduction. And let me first congratulate the whole RM NLU team and you for organizing such a fantastic concept and executing this. I have pleasure to be part of this effort of RM NLU and yours. And I'm very happy that I have been given an opportunity to address a session on restructuring, compromise, and arrangements. Dr. Hiral Mehta has set the tone for the management discussions. What happens before we actually venture into the legal process of restructuring? This is typically what Dr. Hiral Mehta has outlined. This is the typical discussion which happens in the boardrooms and the management. Once the management and the boardroom and the board of directors, they have decided after brainstorming on these issues, once they decide, there comes after that the legal process for executing, giving effect to all these structuring, which is called as restructuring, or it can be by way of compromise, or it can be by way of arrangements. So, yeah, restructuring, by the way, is not defined anywhere. So, we will have to depend on the general definition or general understanding of restructuring. Collins Dictionary has defined restructuring as to restructure an organization or system means to change the way it is organized, usually in order to make it work more effectively. So the focus of restructuring is to make the organization work more effectively. Now, depending on how we are going to restructure the organization, it can be divided into two parts. So there can be two broad categories of restructuring. One is that something which can be done by management decision itself. The management decides and the restructuring can be done. It doesn't require any resort to legal processes. Like say organizing the departments or delegating the authorities or relocating the decision-making authority from one person to another. These are the internal management decisions. It is this also can be termed as restructuring because it involves effective functioning of the company. There are other kinds of decisions of the management which will have an impact on the balance sheet. The moment we have an impact on the balance sheet, we may require help of legal process. This will require resorting to legal processes which are provided under various sections of the Companies Act. There are also, suppose there are in COVID scenario, there were certain situations where the companies have requested the vendors and the consultants.
May I take a minute?
Yes.
Few people are complaining regarding some audio issue. Can you be little louder or keep your microphone little nearer?
Sure. Is this better?
Yeah.
Is this better? Yeah, fine.
Yes, thank you.
So, impacting balance sheet, there can one measure, one step series of activities, series of decisions which were taken by various companies in COVID scenario is that they requested the vendors and consultants to to reduce their invoices. So this also, what happens, this impacts the balance sheet, but it may not require any any resorting to legal processes. This could be done, this has been done by resorting to mutual agreements and amending the agreements and the contract, the understanding between the vendors and the companies. So, but it does impact balance sheet. So, because the liability in the balance sheet comes down, so it impacts balance sheet. But still, we have not yet gone to the courts, or we have not resorted to any particular provision of the Companies Act. Then, in which scenario we go to the courts, or we take help of other provisions of the Companies Act? When we have multiple factors to make the functioning of the company effective, when we have such a plan which is a wholesome plan and it requires tinkering with multiple factors, then at one stretch we need some window where we can do all this in one stroke. This is so single window mechanism was needed, and it has been held by the various courts that this section 391 to 394 in the earlier act is a single window mechanism, though several things within the scheme could be done by resorting to other provisions of the Companies Act, but we need not go one by one and avail follow those sections one by one and achieve the object. Instead of that, we can draft a scheme and get it approved by the interested parties like shareholders and the creditors, mutual adjustment of rights and obligations, or even beyond that, merging some other company or demerging a particular unit for various reasons, which the reasons are part of the board discussions. Once that board discussions have taken place and the management had decided to give effect to this restructuring, they come under section 391 to 394 of the previous act, and now section 230 to 232 of the new act. So now we also have some restructuring that is apart from the management discussion. We also have restructuring under IBC, but then once we go to IBC, it also again directs us to section 230 of the Companies Act. Therefore, whatever we do, wherever we go, whenever we talk about restructuring, everything leads to section 230 and the 10 sections, the chapter 15 of the new Companies Act. Even under IBC, when the company, the corporate debtor has come into liquidation, the rule was inserted, amended, and the rule 2B was inserted with effect from July 2019, and it directs that it should go to section 230 of the Companies Act, though there is a time limit prescribed of 90 days. Yes, it has to be completed under IBC if it is under IBC. However, IBC is not resorted for the purpose of restructuring. It may so happen that at the time of liquidation a need is felt that somebody is interested in restructuring, and at that point of time they can take help of section 230 to 232. Now, restructuring those aspects which impact the balance sheet, like say buyback, reduction of capital, or several other things, or straightaway acquisition of a company which will increase the assets and reduce a subsidy into absorb the subsidy into the company. These big wholesome decisions can be effected by way of a single window clearance instead of going to separately to buyback or separately to reduction of capital and those things. Instead of that, the court has recognized the block of sections 391 to 394, which is now 230 to 230, 40, chapter 15. In PMPO auto industries, the Bombay High Court first held that it is a single window clearance system, and there is no need for the parties to go to avoidable, unnecessary and cumbersome process of making repeated applications to the court for various alterations or changes, which must be needed effectively to implement the sanctioned scheme whose overall fairness and feasibility has been judged by the court under section 394. So now this was recognized that it is single window clearance. What it means, single window clearance, is really a very useful concept. Why? Because it enables me to take help of this for whatever I could not do in any other provisions of the Companies Act. The whole Companies Act, it permits that certain things can be done, but there are several other things for which there are no provisions in the Companies Act. What do you do with that? So this single window clearance, that the block of 230 and 232 now is the window under which you can do anything which the Companies Act does not have provision for. So that is why it is called single window clearance, and it is very important for the corporates because this is the enabling section. Now coming to the legal process of what is merger. Okay, here it will be relevant to mention that the word merger is not defined in the Companies Act. Word demerger is not defined in the Companies Act. Whatever we do is either compromise or arrangement. So basically we draft a scheme of compromise or a scheme of arrangement. We also, in practice, we have started calling it a scheme of amalgamation or a scheme of merger, but it's not that merger or amalgamation is defined. Now, what is defined, wherever we see the definitions of amalgamation, it is under the Income Tax Act or under accounting standards. But those definitions are for the purpose of treatment in the books of accounts or for the purposes of taxation. Not that it will define the character of merger under the Companies Act. Companies Act is the mother for merger. Whatever, if you want to do merger, if you want to enter into any compromise with other stakeholders, you will have to come under 230. Only as a result of 230 and 232, whatever happens after that, what will be the tax treatment, that will be defined by the Income Tax Act. So the leading section, the leading act enactment is the Companies Act, not the Income Tax Act, or the definitions are not relevant for the purposes of making application in the Companies Act. Now, when we come to Companies Act in NCLT, we will see that there are two broad stages. One is company application stage, and another is company petition stage. Application, petition. In the application, we basically make prayers to the NCLT of the jurisdiction that the meetings of the stakeholders can be waived, or the meetings of the stakeholders can be ordered. If it is to be ordered, chairman to be appointed and scrutinizer, date of the meeting, those things will be ordered. Now, who are the stakeholders at this stage? It is the creditors and the members, because under section 230, the eligible persons are the company scheme between company and the creditors, and the scheme between company and the members. But after having satisfied the conditions of company application, once approval of the stakeholders has been taken and the statutory authorities have given their clearance, second motion, we colloquially call it second motion, petition is made. At that point of time, that application, that is called petition, company petition. A company petition is made, and the prayers will be for ordering the merger or demerger, or sanctioning the scheme of compromise. So it is only in the petition stage, second motion stage, that the scheme is ordered. In the first motion process, what we do is to draft the scheme, and valuation, swap ratio, list of creditors, list of shareholders will be determined. And one important thing which has come under section 230 is that certificate for accounting treatment in the scheme to be necessarily given. Earlier, this was not necessary. But once we make application to the tribunal to hold shareholders meeting, it can be made either by the company or any creditor or any member, or even the liquidator if it is a liquidation under IBC. Then the tribunal either orders the meeting or it will dispense with the meeting. For dispensation of the meeting, 90% in value of the creditors is to be required. Only when we have consent affidavit. This is affidavit word is necessary here. Merely consent letter will not suffice. 90% in value of the creditors should consent. Number can be anything at the time of consent. So if suppose if there are 10 creditors and one creditor itself has got 91%, that consent affidavit of one creditor is enough. While dispensation for creditors meeting is expressly provided, there is no specific provision for dispensation of shareholders meeting. So, however, earlier in 391, 394 in the erstwhile Act, the shareholders meeting, dispensation of shareholders meeting was also provided, but it is no longer provided now. However, by practice, the NCLTs have been giving waiver dispensation for shareholders meeting also. So because they have the powers to waive off if there are consents. So here also we follow the practice of giving consent affidavit. Because for creditors, it is the affidavit, consent in the form of affidavit which is required. Therefore, even for shareholders, if we seek a dispensation of the meeting for shareholders, we give affidavit. So once this complete application is heard, at that point of order, these are the orders, contents of the order which will be given, and essentially these are the prayers. Therefore, at the time of hearing of the company application, we should be ready with this information also, because these are the information which will form part of NCLT's order, like fixing the time and place of meetings, appointing chairperson. I should be ready with the name of the chairman, though NCLT may choose that they will appoint from their own panel. However, chairperson, it is the discretion of NCLT. The chairperson can even be the MD of the company. So there is no restriction on who can be the chairperson. We should be ready with the name of scrutinizer. What should be the quorum, suggested quorum, fixing suggested quorum for the meetings, then notice of meetings to be given an advertisement in which newspaper we will advertise the notices. We should be ready with the name of the advertisement. We should be ready with the date of the meeting, and we should know that who are the sectoral regulators, because this will also be mentioned in the order, that these are the sectoral regulators. If there is FEMA, RBI also, if there is any say telecom regulator, insurance regulator, those we should be aware, and we should inform the tribunal at that point of time. So here there was something very interesting about quorum. Quorum, there is no specific mention about quorum. Quorum is the minimum number of persons to be present at the time of meeting to have a valid meeting of the members or creditors of the stakeholders. Quorum. So NCLT was fixing a high number as quorum, purely for the purpose that there should be a broad-based consensus by the stakeholders of that class for which meeting is to be held. However, that was leading to difficulty, because in practice, if you have seen annual general meetings or any general meeting of a shareholder or even creditor, the number which turns out for the meeting is very less. So that was difficult, which was the NCLT was had to be convinced in the beginning when NCLT was formed. So slowly they reduced the number of quorum. Is still the number generally the practice varies from bench to bench, and so when they fix there is a difficulty. Then what was the solution for this if the minimum quorum doesn't turn up? So we prayed in the beginning, and now it has become practice all over the benches, that please provide that please provide in the order that in case the quorum is not present within half an hour, the numbers present shall form quorum. So then after that, the number doesn't matter. Any even two persons who are present will form quorum, and the meeting can go ahead. Then while this meeting is happening and the order under company application has been passed, thereafter there are various and before making company petition, in between there are various compliances which have to be made. We have to intimate the sectoral regulators so that the regulators can give their report to the NCLT, and if they prefer to appear, they will also appear. Generally, they don't appear, but they give through their counsels, they do give the affidavits and their report. We have to advertise the notices of the meetings and send the notices individually to the class of members or class of creditors. But then there is a separate concept of how to determine class, which we will deal with. Then affidavit of service by chairman. So the chairman has to give an affidavit that notices have been served on the shareholders or the creditors. And then we have to conduct the meetings. Chairman will submit its report within 3 days of the meeting. So the company really has to be on its toes. And these are very time-bound process which has no flexibility at all. So if the chairman has to submit his report to tribunal within 3 days of the meeting date, it has to submit within 3 days. If it is the 4th day, then a separate application to be made for consideration of date. And the chairman will not draft the report. The company has to draft the report, help the chairman, and take signature of chairman. Chairman will approve the report, and they have to submit. So it is the primary responsibility in the interest of the company to really be quick on all these compliances. We have to follow up with regional director, which is very crucial. Without regional director's report, the tribunal will not move. Though the regional director of companies, which is the Ministry of Corporate Affairs, though they are required to submit their report within 30 days, and it is also expressly provided that if they do not submit within 30 days, it will be deemed that they do not have any objection. But this doesn't happen. Tribunal will not move without this, in spite of this provision in the Companies Act. Then if there is a liquidator, if it is under liquidation under IBC, liquidator will have to submit its report. Particular, and also in cases of merger, because in merger what happens that one company will get dissolved and will merge with another company, with the transferee. We call it transferor and transferee company. So transferor company will lose its identity at the end of merger. Particularly in merger cases, official liquidator report also is required. But in demerger cases, no company is losing its identity. Therefore, in cases of demerger, official liquidator will not be required to give his report. So no notice to go to official liquidator. Official liquidator is assigned to every high court, but because of IBC, now no new assignments are being given to official liquidator relating to liquidation. Now, when we come to the meetings of creditors and shareholders, there's a concept of double majority voting. This is not unique only to India. Basically, this is a principle, particularly in mergers and demergers, that double majority principle is adopted all over the world. So what it means, so far in the Companies Act, only special resolutions or ordinary resolutions we have seen about this. And only one kind of resolution. Shareholders can simply give 75% and the special resolution approved. Whereas in this block, the single window clearance, 230 to 232, the voting by the creditors or the members will have to be done in this, by this rule. One is that those who are present in person or by proxy or postal ballot, those who have voted, out of that, majority should vote in favor. And this majority should form at least 3/4 in value also. So suppose there are 100 persons who voted. Out of that, minimum 50 plus one more, say 51, should vote. Then only it is majority, otherwise it is 50-50. So 50 plus one more, it need not necessarily be 51, it can be 50.1. So for simplicity, 51. So 51 persons should vote, and this 51 should hold 3/4 in value of total value of 100. So there are double majority rules. So now once voting is done and the chairman's report submitted, now we move on to the second motion process, which is the company petition. Now the company has to consolidate all this, and after this they have to make a company petition indicating therein that all the compliances have been made. These are the records, and then company petition and the prayer for winding up or merger, dissolution of the company or demerger or compromise is to be made. So now after this order has been made, the merger order or demerger order or compromise, this order has to be filed with the registrar of companies within 30 days of the receipt of the order. Now, this is very crucial. In the erstwhile Act, there was express provision that the scheme shall take effect only when the order of the court, order of the merger, demerger, or compromise has been filed with the registrar. So there were two requirements. One, it has to be filed. The order has to be filed, and the order has to be registered with the registrar, and then only it will become effective. So to be filed and to become effective. In the new Act, filing is still there, but giving effect upon filing is now absent. So there are doubts that whether it is necessary that is it that if I do not file, the scheme will still be effective. But you will see that in the orders of the NCLT, they do provide that the scheme to be effective shall be filed with the registrar within 30 days. So now, though it is not in the section, as a standard procedure, the NCLTs have been recording it in the order that for being effective, it shall be filed with the registrar. Then we have to go by the order. So this is a little gray area which is taken care of by the NCLT orders. So you will have to meticulously go through the order and abide by the order. Otherwise, the whole scheme, the whole effort will be under doubt. Now, yes, joint applications are possible. Suppose there is a transfer and transferee, both together they can make an application. Instead of filing two applications, they can file one single application. But this will be possible only when both the companies fall within the same jurisdiction of the NCLT. Because this application has to be made only to the jurisdictional NCLT. So if the companies are in two different states, the joint application may not be possible. Now, once application has been done and orders have been passed for application, then we have all complied with the meetings, chairman's report, everything. We have to submit the petition within 7 days of the submission of the chairman's report with the NCLT. Now, within 7 days, if I fail to file the petition, there is a difficulty. This is a very rigid requirement, and it has happened in Chennai and bench about 4 months back that they delayed, and the NCLT refused the petition. So the entire process was now in doubt that what happens. They made an application for condonation of delay also, but even that the NCLT refused because there is no express provision on the ground that there is no express provision for me to condone the delay in this, neither in the rules nor in the section. So the NCLT expressed its inability and even rejected counter-nation of delay application. So what do we do then? In such a scenario, instead of the applicants, even the creditors and members can make petition. So if the company has failed to make petition within 7 days, the creditors or the members can go ahead and make the petition. So there is still a recourse in such a scenario. If for any reason the company delayed in making the petition, we will have to take help of the creditor or members. We will have to convince them that please you make an application. They can make application anytime. There is no restriction on that. Now, generally when the applications or petitions are being heard, I thought that it would be a good idea to bring before you what are the kinds of queries which tribunals raise at the first motion hearing and at the second motion hearing. At the first motion, which is company application stage, these are the queries which the tribunals generally raise. They have observed and they are very sticky about this. Generally what happens, the professionals, advocates or company secretaries, when they present, they mechanically do copy paste of the objects of the scheme. Objects of the scheme is to be provided in the scheme, because they will look into the objects. What is the object of the scheme? They mechanically copy paste. In some scenarios, even the objects of demerger, which is suitable for demerger, those are copy pasted in the objects for merger. So that becomes very problematic, and the NCLT does not like this, and the scheme can be rejected on this ground. Several schemes have been rejected. So now, under the old act, when it was with High Court did not look much into it, and every scheme, irrespective of the object, was able to pass. But in the NCLT regime, NCLT is going through this, and it will be a disaster if we ignore this. Now, they are also looking into whether the amalgamation is in the nature of merger or amalgamation in the nature of purchase, merely for the, not because of the Companies Act, but because for the purpose of accounting treatment. That what are you doing there in accounting treatment? Because accounting treatment certificate also is to be given by the statutory auditor, not by any other chartered accountant, only by the statutory auditor of the company. So they want to see that whether treatment for accounting, certificate for treatment of accounting is in consonance with what is provided in the scheme. Then if it is given by any other professional, the accounting treatment certificate will not be accepted, only by the auditor. So then they are also interested into seeing that what is the effect on EPS after the merger, earnings per share. They want to understand that what you have explained in the objects of the scheme, whether that it will have some bearing on the EPS. After merger, if it is merger, EPS will either be same, or because of some synergy later, EPS may increase. EPS is earnings per share. After merger, the two companies will combine and the earnings will also combine. So now EPS will theoretically remain same post merger, because both entities put together, if you see, EPS may remain same, because depending on the value also you will issue that many number of shares. So already the swap ratio will take care that EPS will remain same. However, because of certain synergies in the long term, the EPS will improve. So post merger, what does it mean, whether in the short run or long term? You will have to explain to the NCLT properly. Then the tribunals, they look forward for a synopsis. If synopsis is not there, they may even give you another date for hearing, that please submit one synopsis, though it is not mandatory, but they will require that you please give a synopsis, and they may give you may lose one hearing. So go ahead with synopsis, and along with the application itself, you may prefer to submit synopsis. Then if there are creditors and shareholders who are corporates, You know that corporates decisions are taken only by board resolutions. So if the consent or voting by the corporate creditors or shareholders are being placed before the NCLT, this should be accompanied with the board resolutions of those creditors that so and so person is authorized, and that authorized person only should sign the consent or the voting if it is postal ballot. So these are the questions for first motion. Second motion will generally go around the observations of the RD, official liquidator, or income tax, or any other authority. So it depends on what kinds of observations RD has given or income tax has given. Generally, what happens is that the RD will raise these kinds of objections. I have only selected a couple of objections. There can be, it all depends on the case and the compliances by the company and what kind of scheme is being submitted to the NCLT. But here, in some schemes, you will see that the name of the company is also being changed. They will object on this. The RD will object on this, that no, please, there is a restriction on the name. For 2 years, you cannot use the same name because the company has been dissolved. Even for 2 years, it cannot be given. Irrespective of that, NCLT may still sanction the change in the name. Then authorized capital. What happens in merger? That the transferor company's authorized capital will come and get clubbed with the transferee company. Then the authorized capital of the transferee company will go up. In such case, earlier, because of the High Court's order, they did not used to pay the statutory fees or stamp duty for increasing the authorized capital, on the ground that anyway the fees and the stamp duty has already been paid by the transferor company, and that only is coming and getting clubbed with the authorized capital of the transferring company. So everything is already compared with, all the fees are already paid. But over a period of time, the MCA has felt that they keep increasing the rates of authorized capital. So currently, whatever is the rate of authorized capital, it is in place. The slabs keep changing. So the fees may be different. It may be higher. So for that purpose, they will object. And the NCLTs have been obliging, and they will write this in the order that the necessary fees and stamp duty shall be paid. Now, specific to demerger, there was one particular objection. This is very interesting because this was purely related to authorized capital. See, in cases of demerger, it becomes very interesting in terms of authorized capital. The company in this elite core, the Gujarat High Court had given that companies, the one undertaking was getting demerged and getting merged into another company. So they wanted the authorized capital also be bifurcated and to go with the another company. So here, transferor and transferee, we do not use demerged undertaking and demerged company and a resulting company. These are the three terms which are used in demerger. So now the RD objected that there is no system, no manner in the Companies Act to ascertain the unit-wise or undertaking-wise authorized capital and business-wise bifurcation of the authorized capital. But then the court said that it is single window clearance. Whatever is not provided at any other place in the Companies Act, that can be dealt with by us under this scheme. That's why this window is very crucial for a corporate. Then on the same aspect, the RD had raised this objection also, that there is no mechanism in the Act to devise also. There is no concept of bifurcating and also to devise bifurcation of authorized capital and give credit for the fees and stamp duty. Cannot be paid. So here the focus was how will MCA give credit to the fees and stamp duty. Then there is no provision next objection was that there is no provision of reducing the authorized capital of a company. So bifurcation is one thing. Here, because of bifurcation, what will happen? The authorized capital of the demerged company will get reduced. The RD said that there is no such provision in the Companies Act for reducing. How will I reduce? Again, High Court says this is single window clearance. Whatever you cannot do in any other place in the Companies Act, you can do it here. Well, so then they resorted to MCA 21 system because it was 2012. After 2006, the electronic system came, which is known as MCA 21 system. Prior to that, prior to 2006, it was physical mode. So now, next query, next objection by RD was that MCA 21 system does not allow the registrar to effect such reduction. Even if you order, my MCA 21 does not allow me. Even if I'm willing to reduce the authorized capital, I will not be able to reduce. High Court still says that no, you cannot stop me just because of your system. Your system has to be tuned. If I am giving order, your system has to be amended so that there is no problem in giving effect to my orders. These are very crucial things. These are just for example, I brought this before you. Now, for the purpose of voting and conducting the meetings, the determination of class of members and creditors is very crucial. Because how to now determine class of members? The double majority voting rule is to be applied for every class of the meeting. So now the courts have basically set the thumb rule for determining class of creditors. A few facts which we should keep in mind is that it is not the court's responsibility to determine the class of creditors or members. It is the company who should determine the class of creditors or class of members. If the company doesn't do, then the NCLT may step in and say that no. So they have power to determine, but they will not determine if it is correctly determined by the company. So the company, what is the thumb rule for determining class? There is no, first of all, there is no provision for determining a class. So you will have to go by the general rules which are applied by the courts. The courts have generally held that homogeneity or commonality of interest, or what are the compromise terms which you are offering. Suppose in the scheme of compromise, you are asking the secured creditors to bring down their rate of interest or to bring down their outstanding obligation. But you are not touching the unsecured creditors, you are not touching the trade creditors, then you need not, then the secured creditor will be one class and unsecured creditor will be another class. Suppose there you are not touching secured creditors or unsecured creditors, you are only touching trade creditors. Then secured unsecured you can bring in one, whereas trade creditors will have to be another separate class. So trade creditors can be clubbed with unsecured creditors or can be made a separate class also. So there is no fixed, rigid formula of determining. It is the commonality of interest and what is the clause which you are providing in the scheme with respect to a particular class. If you are providing something, then it becomes a class and you will have to separately conduct a meeting, separately a chairman, separately a scrutinizer and the chairman's report. So similar views have been also discussed by NCLAT in 2017 in Cyrus Investments Private Limited. That data you are aware that what has been. So next question arises is that these are the questions which have been raised time and again by various professionals that can buyback be part of the scheme. Earlier, and another that can reduction of capital be part of a scheme. Earlier, buyback could be done under the scheme because there was a judgment in 2003 in the Sterlite Industries case. Because of that judgment, buyback was permitted in view of as part of the scheme. And there was no express provision prohibiting or prescribing buyback in the scheme. The court said that it is a single window clearance mechanism. I will approve buyback. So let there be buyback also from part of scheme, granted. And after that, buyback also could form part of the scheme. So but that cannot be only thing in the scheme. There has to be several other things, and buyback will incidentally be only one incidental part of the scheme. Then fine. Otherwise, if buyback is being done only through the scheme, then it may not be permitted. The court will see through it and it may reject. It is not that now that it is not permitted under the new act, buyback. It is still permitted, but there is an express provision under subsection 10 of section 230 that such buyback shall be in accordance with the provisions of section 68. So it can be part of the scheme, but that part which deals with buyback should also comply with section 68. The conditions like debt equity ratio and all that. So those should be complied with. Now, but so why a company will come under 230 and make buyback as part of the scheme, and what is the benefit? In 230(10) does not make specific mention of section 70. If you go for buyback under section 68, there are certain prohibitions and restrictions under section 70 provided. If you suffer from section 70 prohibitions, you will not be able to do buyback under section 68. But if you come under section 230, you will be able to still do buyback if you comply with those conditions of 68 alone, not necessary that 70 will be complied with. So buyback can still be done, but we have to be little cautious to see that certain conditions are met under 68. Earlier, no conditions were to be met. So as a conclusion, we can say that buyback is still permitted, but there are certain conditions. Now the question arises whether reduction of capital can be part of scheme. It is expressly permitted. Basically, if you see explanation to section 230, it expressly permits that reduction of capital can be part of the scheme. More so because for reduction of capital, anyway, you have to come to the NCLT. And under 230 having been come to NCLT, why not permit reduction of capital also before NCLT? Let NCLT decide. Earlier, there was express mention that compliance of section 100 conditions shall be met. So earlier also reduction of capital was permitted, but compliance was to be seen that compliance of section 100 was also done. Now there can this related party always comes into play, because in cases of merger, particularly when it is group the group companies being merged or demerged, the question arises whether is it not a related party transaction. So in 2014, this confusion was addressed by the MCA that if the scheme of arrangements or these schemes are approved under 230, 232, then section 188, which is related party transactions under the Act, will not be attracted. So this is the procedural part. We will see judgments later in the presentation. So I'm first covering the procedural parts. So now once this is 230 to 232 is merger through NCLT. Section 233 is merger through the regional director, which procedure-wise is less. Therefore, it is nicknamed as fast-track merger. This expression, fast-track merger, is not coined by the Companies Act. It is coined by the professionals. Fast-track merger. So, well, here the whole basically there's not much difference also, because the only thing that in the process, chairman, all those things are cut short, because we have two small companies, or holding company and its wholly owned subsidiary, being merged or demerged. That is still a question whether demerger is possible under 233. But okay, for the moment, okay, merger between two or more small companies, or merger between holding company and its wholly owned subsidiary, then only we can avail the route of 233. And since these are small companies and these are only holding company and wholly owned subsidiaries, why require them to go through that rigorous process of NCLT. That was the ratio because of which Section 233 was introduced. This concept was not there in the erstwhile Act. Here in 233, we have additionally we have to give declaration of solvency, and here also double majority rule for voting comes. But this double majority rule of voting is a little stricter than compared to Section 230, because here majority of members and creditors at a meeting, they have to give, this is same as in 230. But the second, the value, 90% in total value in case of creditors have to give their consent. Whereas in 230 it was only 3/4 if it was a meeting. There is a little bit of a trick here, but when it comes to shares, it is total number of shares, not value. So if the face value of the shares are different, then there will be a problem. And that, what is the number? Suppose face value 10, face value 5. And then if I only see the total number of shares, there will be a difficulty. But section provides like that, only total number of shares. Instead of number of shares, they should have provided a value of shares. Whereas it is correctly provided in case of creditors, value in case of creditors. So apart from this, these are the two main ingredients of Section 233. And there are certain annexures to be attached, one application to be made to regional director, and the process is through. Now, there is one difficulty I see under Section 233, and I am particularly very hesitant in going under Section 233, is because regional director is only an officer of the MC. It does not have power to interpret. In case there are some complexities, certain issues which will require some kind of interpretation and decision, regional director will hesitate in taking the decision. It will, then your scheme will be in problem. So we have to properly visualize and see that, is there any gray area which will need interpretation? If not, okay, we can go ahead with Section 233 merger. If yes, then we should opt NCLT route. So in 233, it's not that 233 is mandatory in case of these companies. We still have the route of NCLT. We have this additional route in case the company opts. So it is the option of that. Now, as the merger is over, now what happens? Once merger is over, the company has been amalgamated. And in case of demerger, this problem will not arise. But in case of mergers, this preservation of books and papers of amalgamated companies will arise. It is very, very crucial. In Dalmia Jain group of companies, this situation arose long back. And I will take you through that history. This Section 239, which requires preservation of books and papers, is basically verbatim of Section 396 capital A of 1956 Act. So we can interchangeably use 239 and 396 capital A. This 396 capital A was inserted in 1965. Prior to that, what was the scenario and how in 1965 only it came? This particular section provides that books of transferor company shall not be disposed of without the prior permission of the central government. We will compare this with what is there in Section 209 relating to maintenance, preservation of books and papers in case of a running company. Now, but let us see the section first. 396 capital A in cases of merged companies, amalgamated companies, transferor companies. And so it provides that books of transferor companies shall not be disposed without prior permission of the central government. If you go to central government, which is nothing but regional director, the central government will appoint one person to examine the books and papers to ascertain whether they contain any evidence of any fraud at the time of promotion formation or at the time of running of the company, of the transferor company. If yes, then there is an opportunity for the MCA to step in and take action against the transferor company. That is why it is that they wanted this discretion to be retained with the central government, that at any point of time, if they should be able to investigate into the fraud, if at all, because they suspect. Why do you want to merge? One purpose, it is in most of, rather in lots of companies, it is a strategy that merge the company, it will get dissolved. And the company is no longer in existence, so it will not come in the radar of the authorities. So it is a way to hide, it is a veil to hide the companies from the eyes of the something has already been perpetrated, and I want to come away of the eyes of the regulators. This is one of the ways. So the government is aware, they wanted to keep this discretion. So you will see that now practically what it means. You will again have to go back to the provision. Provision is this. Second bullet. Section provides that books of transferor company, only transferor company. Transferor company shall not be disposed of without the prior permission. So does this mean that the books of accounts has to be maintained practically perpetually? Is that the intention of the law? Unfortunately, this seems to be the view. Then in section 209, it provides maintenance of books and records for 8 years. Does it mean that this our section 239 and 396A has to be read in harmony with section 209, 8 years? And is it that we can argue that this perpetuality is applicable only in cases where the documents of a running company were required to be maintained perpetually? There are two kinds of documents, the books of accounts of a running company, one which can be disposed of after 8 years, which cannot be disposed of. It has to be maintained perpetually. So can we apply the same thing here also? The Act does not clarify that. So let us see in the history what happened, how this perpetuality came into existence. In 1956 Act, it was the section 209(4)(a), which requires 8 years maintenance of documents for 8 years. This itself was not there in 1956. It came only in 1960. After Dalmia Jain companies, inquiry of Dalmia Jain companies were done. They realized, the government realized that there have been mass scale fraud. And Dalmia Jain companies, they have merged the companies and immediately destroyed the records. At that point of time, the records were, there were certain liquidation also, and the official liquidator also destroyed the documents immediately. So there was a committee formed, and the committee observed all this. On the recommendations of the committee, this was inserted. Now, under the chairmanship of Tendolkar, there is a special Commission of Inquiry Act. The Companies Act, whenever there is an inquiry, inquiry is different, different than inspection and investigation. Inspection and investigation is provided under Companies Act, but inquiry of fraud and all that, when it happens, it does not happen under Companies Act, it happens under Commission of Inquiry Act. So under Commission, even today, Commission of Inquiry Act was under that, a committee was constituted under chairmanship of Tendolkar, and later presided by Shri Vivian Bose, and therefore it is also known as Bose Committee, Bose Commission. They recommended, they observed this, that it will be good to read section 209(4)(a), that 8 years of a running company. It provides that the books of account of every company relating to a period of not less than 8 years immediately preceding the current year shall be preserved in good order. And section 550, it is the observation of Vivian Bose. Now, and section 550 provides for preservation of books in winding up. So 550 provided for winding up, 209 provides for running up. The commission noticed in many cases that where liquidated companies were amalgamated with other companies, the amalgamating company took charge of the properties. Naturally, transferee company, they will take charge of the properties, including the books of liquidated company. The transferor company gets dissolved, gets liquidated. So, and within a short time, destroyed the books as being redundant for these purposes. We have cited various instances of this practice in the first part of our report. So they have observed the amendment to the Companies Act, as mentioned above, means 209, that amendment in 1960. The amendment to that Companies Act, as mentioned above, appears to have taken care of this practice. Means when you cannot destroy within 8 years. But there is one circumstance, 550 for winding up, then 209 for running companies. In both the cases, they are providing for a period. But there is one loophole the committee is observing, where a company is amalgamated with another company without being liquidated. The Act is silent on this point, and it is therefore recommended that. Now see what is that they are recommending. Where a company has been amalgamated with another without liquidation, the provisions of Section 550 shall, notwithstanding there being no liquidation, apply to the transferor company, and it should be made incumbent on the transferee company to retain the books in order for a period for which it has been directed so to do. Still, there is no period. It is only a recommendation that please amend and provide for maintenance of books of accounts. So, subsequent to this, there was another committee, Daftari and Shastri committee, which recommended that notwithstanding the completion of winding up. So there were two committees which gave recommendation for this maintenance of books of accounts of amalgamated companies. The books of the company so wound up or amalgamated should be preserved in their entirety. The word entirety was crucial. Exactly, in 396 Act also they have provided on the similar lines. They say that without prior permission of the central commissions, central government should not be destroyed. Now, now there is a problem. It means, if multiple questions arise out of this, that okay, if I have been amalgamated, fine, I will maintain the books and papers, but for how long? Entirety. If big companies have been merged, then there is a difficulty in maintaining all those books of accounts. Something may become irrelevant. I'm talking about genuine cases where there is no fraud. Then there is another question which will arise, that if this transferee company itself later gets liquidated, liquidator is appointed, IBC action, and the company has to be liquidated. After liquidation, what happens to that books and papers? It will be in violation of Companies Act of this section 239 and earlier 396 capital A. We can take recourse that of the provision under IBC, that notwithstanding anything contained in any other act, IBC will prevail. So if it is liquidated under IBC, we may say that okay, this will not prevail, but there will be some confusion, some questions later. Let us see what is the practice of other companies in other countries relating to preservation of books. Why this is very crucial is that because it adds a big cost and a burden and a responsibility on the company which undergoes this scheme. So this this is a problem. And this becomes a very crucial problem. Today you talk to any liquidator under IBC, the biggest worry for them is that how do I maintain the records? So that is one crucial aspect which is coming to the light now, to the attention of others. In Singapore, if you see, there is no provision prescribing any period for maintenance of books and papers after amalgamation. Though they have consciously provided for 5 years in case of winding up, but they have not provided for maintenance of books and accounts upon amalgamation. Similarly, in UK, only 3 years in a company, that too after winding up. 3 years in case of a private company, and 6 years in case of a public company. So there is a limitation on, but there is a requirement for preservation, but only in cases of winding up. Not the countries predominantly have not provided for preservation of books upon amalgamation. I have taken an example of these two countries, but I have not yet come. I have done my search on other countries. I could not see any such provision in any other country. Then there is another concept which has come expressly under 234. Earlier, it was only inbound merger which was permitted. Now, in the New Companies Act, it is both ways, inbound and outbound mergers. Inbound means the foreign company, the company incorporated, foreign company has a different meaning under Companies Act. So, but permit me to use loosely the word foreign company. Company incorporated abroad, the foreign company, if it gets merged with Indian company, that was permitted. That is inbound merger. Outbound merger is an Indian company gets merged with a company, foreign company abroad. This was not possible under the old act. Now in the new act, it is possible. However, even earlier, the RBI approval was required. Even now, RBI approval is required. It has to be in compliance with FEMA. But since it was inbound merger earlier, there was not much of a problem. Because it is the shareholder Indians who will get the shareholding abroad and the foreign company will get merged with this. So there is no ODI. It is only branch outside India. So there was not much of a problem. But because of cross-border, the RBI has for the first time come with regulations, because in the Companies Act also it is provided that it should be done with RBI recommendation. So RBI has come with regulations, and it basically it gives general permission. So you don't have to go to the RBI for its approval. As per the regulations itself, it has given general permission. General permission, if you satisfy these conditions, then you don't have to come to me. If you are under automatic route, if you are not exceeding the sectoral caps, in most of the companies, unless and until it is regulated sector, say telecom and all, there is no cap, 100%. So, and the valuation should be in compliance with FDI and ODI norms. Then it is permitted, you need not come to me. So, and in case of private banks, the government banks, they have their own banking act, and they will be regulated by that. But when it comes to private banks, merger of private banks, then there is a certain direction by the RBI. They call it directions, amalgamation of private sector banks directions. And section 230 to 232 of the Companies Act is not applicable to private banks. They need not come to the NCLT. Instead, they can just go to RBI. And there also double majority voting is required. And it is same as what is there in section 230. You don't have to take approval from creditors. So looks like the merger of private banks is easier than companies. However, merger of NBFCs with private bank will need approval of NCLT. So if NBFC is getting merged with private bank, two private banks, no problem. If NBFC with private bank, you will have to still come to NCLT. Then with this we have finished our process part, and we come to the judgments part. Let us see what are the judgments. There are hundreds and hundreds of judgments. There is no dearth of judgments, but very crucial ones I have picked, and within the time frame in which we have to finish on these considerations, I have selected a few. One I will like to bring before you is the judgment and the observations of Justice Dhananjay Y. Chandrachud given in the case of Iron Exchange. It has set the tone of merger. It has been really giving direction that what is the thing which the judges, which the courts should keep in mind while evaluating any scheme, while evaluating any application. Evaluating the scheme, courts do not generally do that. They do not evaluate the scheme because there is nothing good or bad scheme. So they do not evaluate the scheme, but what is that they should keep in mind? See, what is happening is they have Justice Chandrachud has particularly expressed that law as evolved in the area of mergers and amalgamation has recognized the importance of the court not sitting as an appellate authority over the commercial wisdom. So what will be the scheme? Please do not sit. The courts should not sit on the commercial wisdom of the stakeholders. Then the second observation he has given, which is very important, that law should be slow to retard or impede the discretion of corporate enterprises to adapt itself to the needs of the changing times. It is the businessmen, it is the companies which know that what is their need. And if they want to do some restructuring the scheme, court should not come in between and start evaluating, because one is that court is not competent to do business evaluation. So they should not unnecessarily come and throw a spanner. So that is what this observation was very crucial, and it really gave a direction to the courts for in the future. Then I typically regard this particular judgment, no discussion about mergers or a scheme is complete unless we mention this particular judgment. Mihir H. Mafatlal versus Mafatlal Industries in 1996 by the Supreme Court. I call this as torchbearer judgment. If you have any doubts, if you have any questions, you might find an answer in this judgment. This judgment, I have picked several aspects which have been decided in this judgment, and under heading, I have made headings and I have brought it before you. Here in this particular case, there was a minority, Mihir H. Mafatlal, at the time of certain business family arrangements was done and settlement was being done. He was a minor. When he became major, the scheme was proposed. At that point of time, he intervened in the scheme. He had he was in minority also in terms of shareholding. He raised doubts on bona fides of the majority voters. That 3/4 approval has been given, fine, but they are not bona fide in their intention. This is only to suppress and oppress the minority. Then the scheme in question, and here the person whose personal interest might be different from the interests of the voters as a class. This is the observation given by the court, that it is your personal interest, but as interest of the voter as a voting, the two interests are different. So we will not get burdened with your personal interests. The court has given its observation. It is not possible to agree with the contention of learned senior counsel for the appellant that the majority had acted unfairly to the appellant and had not protected his interest of minority shareholders falling in the same class along with the majority. So bona fide of person can only be relevant if it can be established with reasonable certainty that he represents majority or is a controller of majority. So here it is trying to say that the majority, particular majority has commanded over other people and got majority vote. One person has commanded over other and got the majority, then bona fide can be doubted. But in general, if all the shareholders have voted, and because of which 3/4 was they accorded affirmation to the scheme, no, that cannot be doubted. So just because some people are aggrieved, the decision of the majority will not be ignored, and the bona fides will not be looked into. So, so they are giving here, but they have classified. The Supreme Court has given further guidance as how, in which scenarios, what are the scenarios in which we are actually looking to bona fide. When it consisted of outsiders, so here in this particular case, there were outsiders like financial institutions. It consisted of outsiders like financial institutions, or that there was any possibility of their surrendering their economic interest in the scheme at the dictates of shareholder director. Meaning it is not possible to imagine that these financial institutions will surrender their economic interest just because a majority shareholder has commanded them. No, so we cannot doubt the bona fide of bona fide of the majority shareholders. So that bona fide of majority shareholders was again rejected. Let me complete this judgment Mihir H. Mafatlal, this particular point, and then we can also take up some questions. Now, in the case of Hellenic and General Trust Limited, in this particular case only, Mihir H. Mafatlal case, the Supreme Court gave reference to Hellenic and General Trust Limited. And it was in that particular case, in Hellenic, that ordinary shareholders were to be cancelled. The ordinary shares were to be cancelled and new shares were to be issued by another company, to another company, and this transferor company would become subsidiary of another company. And the holders of such cancelled shares were to be paid by Hambros at 48 pennies. Yes, you are saying something, Amitji? Amitji, you are saying something? No. Your voice is breaking.
Yeah. From the participant, if you can be little slow
Okay.
in forward. They are not able to follow. We have enough time, we'll be able to complete. So nothing to worry. Please go ahead. Go ahead.
Okay. So here I would take you through that what happened in Hambros. In Hambros, that shares were to be issued and to be allotted to the holding company, which would, upon this transaction, this Hambros will become holding company, and cash was to be paid to the shareholders of the transferor company. As a result, what happens that the shareholders are going out. The shareholders, so in short, if we can say 53% shares of the Hellenic company were held by another company, MIT, and MIT was wholly owned subsidiary of Hambros. So 53% of this transferor company, Hellenic, was held by MIT, which in turn was the wholly owned subsidiary of Hambros. And on the other hand, by way of merger, Hambros was being allotted all the shares of Hellenic, and Hambros paying cash to the shareholders of Hellenic. That means 100% control on the transfer company was going to be going to be held by Hambros. Therefore, the court raised its objection that this is not merger. This is, you are throwing other shareholders out. So they lifted the corporate, they lifted the veil of merger, they lifted the veil of scheme and said that no, here it is not a bona fide interest. So in this Mihir H. Mafatlal, the Supreme Court has been really wise in going into details that in which scenario the bona fide of the majority can be questioned and in which scenario it need not be questioned. So here they have given examples that in this case it was questioned. So we have to keep this in mind that if we are drafting the scheme, this judgment is going to be very helpful for us. That's why I said Mihir H. Mafatlal is really the torchbearer. That what was required to be considered while sanctioning the scheme was bona fides, with respect to bona fides of the scheme, acting as a class and not of one single person. So this two judgments, Mihir H. Mafatlal and the Hellenic merger, these two together throw some light as to what can be considered as bona fide, mala bona fide of the majority shareholders. Next question, Amitji, if we have some questions so far, we can take it up. This is another query which objection which was addressed by the Supreme Court. Before taking up this query, maybe we can take some questions. You can interrupt me when you want.
Sir, I have a question if I can ask.
Yes.
There is a stricter majority rule which is required under Section 233 merger, that is the fast track merger. So, what if
Yes.
two small companies want to merge? Can they go by the normal way, or is it compulsory for them to go by 233?
This is one doubt which arises. We are completely free to go to NCLT. So, and it is a matter of strategy that we decide whether we go under 233 or we go under 232. So, in case you have too many creditors, you may prefer to go through, and if you are not able to get the consent, you may like to come through the NCLT. If you feel that certain creditors may raise some objections about this scheme, then you may still want to come through NCLT, because NCLT is the authority who can decide certain issues. RD will not be able to decide certain issues. They are only officers who do not have power of interpreting the sections. They will simply fold their hands and they will say that there is objection. Either I refer it to NCLT. RD has power to refer to NCLT, but only in public interest and those things. So they can refer it to NCLT, but there will be then you go under 233, and again under 232 you again make an application to NCLT. So there will be time loss and huge cost also. So we have to do the evaluation beforehand, and it is purely up to the company that whether they want to go under 233 or under 232.
Thank you. The decision then.
Exactly. So I can proceed.
Yes, Krishna ji, I think maybe you can take one or two more judgments, and maybe
Yes.
we can reserve another 30 minutes for the question answer. We have got some 40-45 questions, so I think in half an hour time we should be able to address. So maybe you finish off the important judgments, and after that we'll at once deliberate and take on the questions.
Okay. So another question which was addressed by the Supreme Court in Mihir H. Mafatlal is that whether the court has jurisdiction to minutely scrutinize the scheme. So now they are talking about whether the court should go into the scheme and see the pros and cons and analyze the scheme, particularly when the majority of the creditors or members or whatever, they have approved it. In such a case, will it be wise for the court to go into the scheme? They observed that commercial wisdom of the parties who have taken an informed decision about the usefulness and propriety of the scheme by supporting it by requisite majority vote, that has to be kept in view by the court before. So they are not straight away saying that you need not go into the scheme, but please have this in the mind. The court does not has neither the expertise nor the jurisdiction to delve deep into the commercial wisdom. So broadly, the courts are of the view that they should not scrutinize this. So here they are limiting the role of the courts, that court acts like only an umpire in a game, that the game is played fairly. Nobody is cheating. That's all. You cannot go into how the batsman should hit the ball. So you are only an umpire in a game of cricket who has to see that both the teams play their games according to the rules and do not overstep the limits. That's all. So you cannot require them, or it is not your role to ask them how to hit the ball or how to ball and which ball to throw with and all. So they will generally, the courts will keep themselves away from such things. The court cannot therefore undertake the exercise of scrutinizing the scheme. This has been the judgment of in the Mehir H. Mafatla. Third question which was addressed is that what are the contours of the jurisdiction of the court? This also the Supreme Court laid down. So the contour basically it is related with the same previous query, that the court has to see whether all the requisite statutory procedures have been followed or not. whether majority have voted, whether chairman was appointed, whether they have given proper reports, whether the objections of the statutory authorities have been considered. Those are the things. So only broad contours, only the compliance of the sections of the requirements have to be looked into by the court. So these are the presentation will be shared. Maybe I will read this one, the fifth point. All the requisite material contemplated by the provision of subsection 2 of section 391, which is now 230 and 232, is placed before the court. So material contemplated by the provisions and those which are material facts should have been placed before the court. And it is not violative of any provision of law, and is not contrary to public policy. These are the broad considerations which the court or NCLT should keep in mind while giving their considering their schemes. Next question in the same case, Mihir H. Mafatlal versus Mafatlal Industries, which was addressed, is how to determine class of members and class of creditors. From here only, the minority shareholder, they said that I am a different class because I have a different kind of interest. So they said that no, equity shareholder is an equity shareholder. So they drew certain parameters for determining class of members. Appellant is admittedly an equity shareholder, they observed. Therefore, he would fall within the same class of equity shareholders. He cannot say that I am a different class. Because the rights are same, the interests are same, personal interest ignored, rights are same, interests are same, so you are within the same class. So the court refused their argument that they are a separate class. However, in a given contingency, it may be contended by a group of shareholders that because of their separate and conflicting interests vis-a-vis other equity shareholders with whom they formed a wider class, a separate meeting of such separately interested shareholders should have been convened. But such is not the case of the appellant. So appellant was only a minority equity shareholder, but at the same time, the Supreme Court goes ahead and says that in a given contingency, they can still be considered as a separate class, even though they are equity shareholders. Suppose their face value is different, their differential voting rights, they can be considered as separate class. So the court is not closing its eyes towards the possibility of the equity shareholders, though equity shareholders, still forming a separate class. But generally, so they are debating with both possibilities and the cases in which it cannot be treated as a separate class. They have quoted Palmer also. In Mafatlal case only, they have quoted Palmer also. And this particularly underlined and the bold portions. The court does not itself consider at this point what classes of creditors or members should be made parties to the scheme. This is for the company to scheme, purports to achieve. The objects of the scheme, so it is left to the company to form a class. Only when the court senses that the company has erred in making a class, then only the court will step in. Otherwise, the court will keep itself away. So it is primary responsibility of the company to form appropriate classes of stakeholders. Like if rights of ordinary shareholders are to be altered, but those of preference shareholders are not touched, a meeting of ordinary shareholders will be necessary, but not of preference shareholders. So it is also pointing to a possibility where you need not go to the preference shareholders for their approval of the scheme. In case their rights are not being touched, they are only the rights of only ordinary shareholders are being altered. So there are lots of possibilities in a scheme, and every scheme is unique in its own way. If there are different groups within a class, the interests of which are different from the rest of the class, or which are to be treated differently under the scheme. So it is talking about two things. Either the interest of the class within the class is different from the rest of the, say, unsecured creditor. Trade creditors and unsecured creditors. Unsecured creditors can be banks who have not given any, who have not taken any security. Trade creditors also can be classified as unsecured creditors, but their interests are different. So either because of the interests are different, either because of that, or in the scheme, you are treating them as separately. Say trade creditors and unsecured creditors can be classified as one class, and a meeting of unsecured creditors wherein trade creditors and unsecured creditors both become part. That is one possibility. Another possibility is that though they are unsecured creditors, trade creditors are unsecured creditors, but in normal circumstances they could be classified as one class, but the scheme talks differently about the two groups. Therefore, because of the scheme, they become a separate class. So it is pointing at two possibilities. So such groups must be treated as separate class for the purpose of the scheme. So then, in the same towards the class of creditors and members, unless a separate and different type of scheme of compromise is offered to a subclass of a class of creditors or shareholders, no separate meeting of such subclass of the main class of members or creditors is required. So, if the unsecured creditors, it is talking here that if unsecured creditors are being treated homogeneously, then there is no need of having a meeting of trade class separately and meeting of unsecured creditors separately. This is what it is trying to cover. Relating to determination of class, because this becomes one of the sticky points when you propose a scheme of compromise or merger. Gujarat High Court in Manik Chowk and Ahmedabad Manufacturing Company Limited, one peculiar thing you will see generally when you see the cases of merger or scheme of compromise, there will not be any respondent. So it is never so and so versus so and so. So, and it is only say here in Manik Chowk and Ahmedabad Manufacturing Company Limited. The moment you see in a case of a scheme so and so versus so and so, that means there has been a dispute. Like in Mafatlal, Mihir H. Mafatlal versus Mafatlal Industries. So that is, there is a dispute. Then only this versus will come. Well, on determination of class, the Gujarat High Court observed that the group who are styled as class must have commonality of interest and ordinarily be homogeneous, and they have been offered identical compromise. So if such a case, if such is the case, then they are one class. So they has the wordings here are clearer compared to Mihir H. Mafatlal. That's why I brought it here. That this gives more clarity. Another point in Mihir H. Mafatlal was considered is the exchange ratio. Can a scheme be rejected on the ground that the exchange ratio, which is swap ratio, it is the ratio at which the shares will be allotted to the shareholders of the transferor company in the transferring company. So this exchange ratio, the ratio at which this shares of the transferring company will be allotted, whether it can be rejected on the ground that it is unfair and unreasonable. So it observes, the Supreme Court here in Mihir H. Mafatlal case observes that valuation of shares is a technical and complex problem which can be appropriately left to the consideration of experts. We will not interfere with the valuation done by the experts unless until it is prima facie objectionable. A reference was also made to the decision of Gujarat High Court in Kamala Sugar Mills case. once the exchange ratio of the shares of the transferee company has been worked out by a recognized firm of chartered accountants who are experts in the field of valuation, and if no mistake can be pointed out in the said valuation, it is not for the court to substitute its exchange ratio, especially when the same has been accepted without demur by the overwhelming majority of the shareholders. If the majority of the shareholders have accepted the valuation, it can be prejudicial to some shareholders. That's fine. But again, here there are two factors. One is that the expert who has done the valuation, an expert has done the valuation. I am not competent, the court is not competent to determine that whether it is right or wrong. Further, this exchange ratio, it is given in the scheme, it is given in the resolution, it is given in the explanatory statement and placed before the shareholders. Shareholders are aware that how many shares I will get. What is left is only commercial evaluation by the respective shareholders, which they have done. So the courts will not be interested in interfering. So with this Mihir H. Mafatlal considerations, these were the important points which were decided in Mihir H. Mafatlal. Now, there are possibilities that the companies are in two separate states. Say one in Tamil Nadu, another in Maharashtra. The application and petitions have to be made to the respective NCLTs. So there will be two applications. One, the Chennai, Tamil Nadu company will make an application to NCLT Chennai, and Maharashtra. Yes, any question? So, a Maharashtra company will have an application placed before the NCLT Bombay. Now, there is a possibility that two courts pass a different order. So, there is a real confusion on this. It is possible. In cases of schemes, there is a chance, and there have been certain judgments also on this, that they discouraged. In Bank of Baroda Limited versus Mahindra Ujjain Steel Company Limited, the judge observed it is somewhat incongruous. So the courts were aware of this fact, and they have time and again advised the department, at that time department, now NCA. They have advised that you please bring some uniformity on this, some guidelines, some provision on this. So like in Bank of Baroda case, it was observed that it is somewhat incongruous that provision be made for the same thing of matter by two different judicial orders passed by two different courts, presumably on two different dates. So there can be two different dates when the judgment has been given. Matter is same. Same scheme is being approved, but on two different dates, two orders, and possibly different orders. Could the legislature have really envisaged a situation of this nature? Is it a situation which can be remedied only by legislative intervention by way of an amendment? So, in a way, the Gujarat High Court here is advising, suggesting that think about it. In Mafatlal Industries case, it was before Gujarat, not the Supreme Court case. The anomaly of a scheme being sanctioned by one high court but not being sanctioned by another has to be avoided by appropriate amendment to the Companies Act. Here the Gujarat High Court came bang on and said that please rectify this anomaly. In Consolidated Coffee Limited, merely because a petition for sanction is pending before another high court, it is not a ground on which the court should be requested to defer the decision until that case was heard. Here, the petitioners had requested the Karnataka High Court that the matter is pending in another high court, so you please defer the decision. So, being aware that there can be two different high courts, there can be two different dates of order, there can be two different thought process going on the same thing. Still, so in this, Karnataka High Court had reprimanded the petitioners that you cannot ask me for this. So in Nokia case, where the scheme did not affect the rights of the members or creditors of the transferee company, it was not necessary that the scheme be examined by the court within whose jurisdiction the transferee company was situated. That was an interesting observation. They say, here they are saying that transferee company, only the transferor company's interests are getting affected, because they will be allotted shares in the by the transferee company, and the transferee company shareholders will not be affected. They are not going to do anything. Therefore, the rights and interests of the shareholders of the transferor company only are getting affected. Therefore, probably there is no need for the transferee company to make an application to me. So this was the observation in Nokia Siemens case, but this was Karnataka High Court's observation. But nobody dares not to make an application. Everybody invariably, as a matter of practice, transferee and transfer company both will make an application. Then another question arises that whether the merits of the scheme can be considered at application stage. In the beginning, we saw that there are two stages: company application stage, company petition stage. Company application stage is only for the purpose of shareholders' approval. Company petition stage is the real stage where these things will be considered. So it was observed by NCLAT in this particular case by Bengaluru bench, MEL Windmills Private Limited versus Mineral Enterprises Limited and another. They had gone into the Bengaluru bench had gone into the merits of the scheme at the company application stage itself, and it was rejected. When on appeal, NCLAT observed that no, please do not do this. The appeal was made against this order. The NCLAT observed like this: it is manifestly clear that at the stage of calling of meeting of creditors or members for consideration of the scheme of compromise or arrangement, the tribunal is not required to examine the merits of the scheme. Any such indulgence on the part of the tribunal would fall foul of the provision engrafted in section 230 subsection 1 and would be without jurisdiction. Very strong words. So NCLAT has very strongly observed that no, at company application stage, we cannot talk about the scheme. So the bench should not talk about the scheme at all. They should only concentrate upon the documents, the meetings, chairman, scrutinizer. These are the only things which should be spoken about at the stage of company application. Then there are doubts raised about memorandum and objects. Sometimes, like if it is a vertical merger, the vertical merger and horizontal mergers, these are the considerations which are basically form part of the discussion in the boardrooms. There is no legal term like vertical merger or horizontal merger. But then, if it is a vertical merger, say two different companies engaged into two different activities, the objects of the memorandum will not match. You know that only as per the main objects, what is given in the main objects of the memorandum, that only the company can undertake. So if now upon a merger, the transferor company whose objects are entirely different, if it is merged, it will result into carrying on activity, because the merger is always on going concern basis. So it will result into carrying on activity, an activity which is not there in the objects clause. So for this purpose, whether the memorandum should consider amalgamation itself as a merger, and if the objects in the merger, the objects of the memorandum, two things. So the courts have expressed for both that upon merger, it is amendment of the deemed amendment of the objects, and amalgamation. On the point of amalgamation, amalgamation itself cannot be the object of the object of the company is to carry on activity, certain business. To amalgamate itself cannot be an object. Therefore, there is no need that there should be a clause for amalgamation in the objects clause of the company. So that clarity was given, and this also I discussed in the previous one, that whether the objects of transfer should be similar or identical. So there need not be unison or identity between objects of transfer company and transferring company. Companies carrying entirely dissimilar businesses also can be amalgamated. So objects will automatically get amended. In Rama Investment Company Limited, the court had an opportunity to examine whether the scheme can be rejected on unfair grounds. This was by Chennai bench, and in the year 2018, which was where minority shareholders they objected to the scheme. It was, however, the NCLT approved the scheme, saying that minority shareholders do not have locus standi to object, since the scheme is approved by 3/4 of the majority. So, and so it particularly observed that since valuation did not consider investments, but when it went to NCLT, it was rejected. The minority shareholders went to NCLT. NCLT rejected on the grounds that valuation, in the valuation there was an error. They did not go into the merits, or they were questioning the valuation itself. It is not that the expert was questioned. They saw an error in valuation. This particular company had investments in another company, which was in the transferor company. This investment was not considered for the purposes of valuation. So, because of which the value of the transferee company came down. So, I mean, the value of the transferor company came down, because of which lesser number of shares to be allotted in the transferee company. So they rejected, because one particular important factor was not considered in the valuation. So there was one prima facie error. So without going into the merits and demerits, on a prima facie basis, they had rejected. So there can be rejected schemes also. Schemes can be rejected. We have to be wary about it. It's not that mechanically it will get approved. It can be rejected also. Whereas in the High Court, the rejection of schemes were very rare, but in tribunal scenario, there have been quite a few rejections. One of the questions time and again raised, that whether LLP can be merged with a company. There are multiple decisions, and now because of these judgments, the floor is now clear. Merger of LLP was considered when 2013 Act came. Around that, it became effective. Around that, there were certain pending cases where LLP was being merged with company. Okay, so you will see that two judgments: Vertis Microsystems LLP. LLP is being merged with another private company, Forgehead Solutions Private Limited. This was decided by NCLT Mumbai, which was decided in affirmative. But it was under section 394, where there was a permission. It was possible under 394, expressly permitted, that they could merge, and therefore that merger was done. So LLP merged with private company, in the case of Vertis Microsystems LLP, but then it was under 1956 Act. Though the 2013 Act was already there, but this application was made under 1956 Act. Then in another case, Real Image LLP with Cube Cinema Technologies Private Limited. In this particular case, this was purely under 2013 Act. You will note that section 230 and 232, that whole chapter, became applicable only later, not with effect from 2014. So, but when it became tribunal, the jurisdiction went to tribunal, this application was made Real Image LLP with Cube Cinema Technologies merger of LLP with Private Limited. In this, the NCLT observations are really interesting to see. The rationale of NCLT Chennai was that under the Companies Act 1956, there was an express provision wherein transferor company included any body corporate. LLP is a body corporate. So, however, there is no similar provision under the Companies Act 2013, since merger of a body corporate, including LLP, with an Indian company was categorically covered under the Companies Act 1956, and there being no specific provision under the Companies Act 2013 to provide for the same, it was reckoned to be case of casus omissus, that the draftsman inadvertently omitted to cover that. This was the observation of NCLT Chennai, and therefore I am permitting merger. So, in a similar case, which was placed before Ahmedabad bench, they held that, but that was a partnership firm. Partnership firm did not fall within the ambit of term company. It should not be permitted to be merged with a company. So there was a partnership firm. LLP also is a partnership firm, but it is a body corporate. But if it is a partnership firm under Partnership Act, it is not a body corporate. So there were two different things considered here. Going back to Cube Cinema, Real Image LLP with Cube Cinema, it went up to NCLT. Here the party who objected was the regional director. And here the NCLT reversed the order of NCLT. It says that no, LLP cannot be merged with a company. So now, because of the NCLT judgment, it is now settled that LLP cannot be merged with a company. That means the only way to do merger of LLP with a company is to first convert the LLP into a company and then propose a scheme for merger between company and company. So LLP becomes company and then the merger between a company and a company. However, still there may be a window. In my view, there is a bit of window here and under section 230 subsection 1, because it says that who can make an application and what kinds of schemes can be considered, who are eligible. So a scheme can be considered between the company and its members, or the company and its creditors. Now imagine if the member is LLP. So there is a window here. That means in such a scenario, if the LLP is a member of the company, then the merger of LLP with company is possible in my view, but so far it has not been tested. Okay, so it needs to be tested, but in my view, all the doors are not yet closed. So there are two ways. One, either you convert LLP into private limited and then go for merger, or make LLP as a member and then propose a scheme between member and the company. One crucial aspect about a scheme, any scheme, is the appointed date. It is mandatory by subsection 6 of 232 that an appointed date be mentioned in the scheme for the merger or demerger to take effect. So, appointed date has to be mentioned. What will be the appointed date? Can it be a rigid appointed date? Can it be a floating date? Can it precede the date of sanctioning of the scheme? Can it be a date which is after the date of sanctioning of the scheme? Several questions, and all are answered in affirmative. Yes, for everything. Let us see the judgments. In Marshall Sons and Company Limited, it was held by the Supreme Court that appointed date may precede the date of sanctioning of a scheme. Invariably, you will see that appointed dates are always a date which actually precedes the sanctioning of a scheme. Sanctioning of a scheme is sanctioning by the shareholders or sanctioning by the court. So invariably, you will see that appointed dates are, say, if an application is made today, they may have appointed date as 1st April 2020 or even 1st April 2019. But there is a restriction of 12 months. We will come to that a little later. Then, in that Marshall Sons case, they also observed that appointed date can be the date of filing of certified copy of the order, because under section 391, 394 block of sections, the scheme was effective only when the certified copy of the order was filed with the ROC. So your appointed date can be the date of filing of certified copy of the order. Therefore, instead of having a rigid calendar date, you can specify that the date of filing will be the appointed date, or even the date of allotment of shares after the merger order has been given. That appointed date can be the date of allotment of shares also. So it is a floating date. Appointed date is not a rigid concept. It can be a floating date. It can be tied, pegged to a particular event. Now, in the matter of merger of Equitas Housing Finance with Equitas Microfinance, the Madras High Court had held that the appointed date need not necessarily be a specific calendar date. So they had said this in very clear words that it need not be a particular calendar date. Subsequently, in 2019, the MCA has come with a clarification which also suggests that it needs not be necessarily a specific calendar date. It says that that section 232, the circular, these are the words of the circular, that subsection 6 of 232 enables to choose and state an appointed date in the scheme. This date may be a specific calendar date. Okay, appointed date may be tied to an event. Okay, so the circular itself goes ahead and it encapsulates all the judgments which we just saw. May be tied to an event such as grant of license by a competent authority, telecom, or fulfillment of any preconditions agreed upon by parties. So parties also can put conditions. Where appointed date chosen is a specific calendar date, suppose we choose a specific calendar date, then in that case, it may precede the date of filing the application, but should not go beyond a year, means 12 months. 12 months before the date of filing the application, that appointed date should not be fixed, which is older than 12 months. But it can still give something which is older than 12 months if they have given justification in the scheme, unless justification brought out in the scheme. So justification for giving a date which is older than 12 months has to be brought out in the scheme. Therefore, it is not prohibited. Any date can be a calendar date. There is no prohibition. The only thing is that if you are giving a date which is older than 12 months, the scheme should incorporate the justification. Then there have been some scenarios in the past where it was felt that merger is not possible. An order has been given, but things are not working out. So can the merger order be recalled? So cancel the merger order by the court. So in very simple terms, it means cancelling the order, merger order. Can the court recall the merger order? Courts have been very broad in affirming this. So they do not want to recall the merger order, but Nevertheless, they have observed this in the in Dharmapuri paper mills. What happened that in one of the instances, some relief has been allowed by Madras High Court, in particularly Dharmapuri paper mills case. After the merger order, 2 applications were made to the Madras High Court to rescind the order sanctioning the scheme. The reasons cited were that the merger order had also not been approved by the board of directors of the company, meaning certain business reasons which were not approved, and the order, they did not take note of the merger order. They did not file the merger order with ROC. Therefore, the merger order is ineffective. Now, kindly rescind the order. Let us see what the court observed. He refused to rescind, stating that it is a suo motu reconsideration by the boards of the companies. Means the boards are considering that let us rescind the order and let us make an application to the court that a prayer be made for recalling the merger order. It is so the court reprimanded the companies. It is not open to company to seek sanction and annulment of such sanction at the whim and pleasure of the boards of the companies. So they do not want to recall the order. Then appeal was made to division bench. So there it was prayed that instead of recalling of the order for merger, an order may be passed for not implementing the scheme. So they modified the prayer in the appeal before the division. Okay, I'm not asking for recalling. Please pass an order that a scheme need not be implemented. Here they gave the order, but with certain reservations as to whether any objection could arise if either the rescinding or non-implementation prayers are allowed. They were wary that if I say that yes, it can be recalled or it need not be implemented, then whether there is any interest of anybody which will be prejudiced. So to take care of that, they directed the companies to advertise in newspapers. This was the protocol which was followed. So there is a case for something like recalling, which was done in Madras High Court. I will not call it recall, but instead of recalling, if you make an application for not implementing the scheme, maybe you have a precedence. But there is only one precedence to my knowledge. So non-implementation of the scheme was granted, but along with the newspapers. However, the division bench, they observed that you did not file the order with the ROC. You have been lackadaisical in your approach. So for the slackness on the part of the appellant, they ordered cost also, which was 5,000 at that point of time. It may be substantial, but still, to show the annoyance of the court ordered cost also. So these are the very important aspects which we will face in any scheme. Now, coming to stamp duty, which probably is the most important consideration, because the stamp duty is the costliest part of the whole process. And invariably, all the companies, they want to save their stamp duty by seeing if something is available. Now, there are quite a few issues, particularly because of the fact that businesses are diversified in terms of location and in terms of products also. So in terms of location also, the businesses of the company may lie in four states. So in different states, if the undertaking lies, and because of the merger order, the transferor company is getting merged with another company, that property lying in 2 states will get transmuted to one company. So now there are issues. There are 4 aspects because of which the confusion arises. First of all, that there was a doubt whether an order of merger is an instrument and whether it can be subjected to stamp duty at all. So the courts have provided, answered this in affirmative, that yes, it is instrument, it is conveyance. But still there is no unanimity, but general consensus is that it is instrument, it is conveyance. So that means it will become subject to stamp duty. The moment it becomes subject to stamp duty, now state stamp acts will become applicable. Now, here is the real problem. 4 issues. One is that the rate of a stamp duty may not have been prescribed in the respective stamp act, means the stamp duty on merger. Stamp duty on properties will be there, but the stamp duty on merger order may not have been prescribed. Then another scenario, whether an order for amalgamation is a conveyance or instrument. By judgments, there have been some judgments that it is conveyance and instrument, but in the stamp act itself, in the definition of instrument, in the definition of conveyance, whether it is part of the definition, because of that also confusion arises. When the third scenario, applications, if applications are made to 2 different tribunals in 2 different states, and so there are 2 orders on the same matter involving same property, 2 orders. So if it is instrument or conveyance, will I have to pay stamp duty twice on in these 2 different orders? Though it is for the same matter. 4th scenario, we will examine all this. 4th scenario, when even though the tribunal is 1, but the property lies in 2 different states, will I again have to go and pay separately stamp duties on the merger order? Let us see. Maharashtra and Gujarat, they have amended their stamp act and brought the order of amalgamation into the definition of conveyance. So now, as per the stamp act, for them it is conveyance and it is liable to stamp duty. So in these 2 states and several other states, there is no escape from stamp duties in these states, those who have amended. So there is no question of any confusion. Then in the state of Tamil Nadu, they have not amended the definition of conveyance and all, but they have amended the Stamp Act to specifically provide for duty on the order of merger, which is 2%. So, which is still higher compared to other states, like in Gujarat. Now, Bombay Stamp Act, let us see what happened in Bombay Stamp Act. This is interesting, that with effect from 1985, the definition of conveyance was amended to include a decree or final order of any civil court. Now, company court orders, merger orders are passed by company courts of the High Court. Now, so civil court. Still, there was confusion even after this 85 amendment. Then in 93, they again amended the definition of conveyance and included the orders in respect of amalgamation of companies also will be part of the conveyance. Then there was the validity was challenged of this amendment in the case of Lee Taka Pharmaceuticals Limited, where the Bombay High Court upheld it. It upheld the amendment of the Stamp Act, and it said that it is an instrument within the meaning of amended Stamp Act and is therefore liable to pay stamp duty on conveyance of property. Like property, you pay the stamp. Then Supreme Court also has decided in the case of Hindustan Lever Limited versus State of Maharashtra that order of merger is a conveyance. Now let us see the rates of stamp duty. Rates of stamp duty in Maharashtra, I have only taken examples important because in Maharashtra number of companies are more. Most number of companies are there in Maharashtra. Rate of stamp duty in Maharashtra is currently 10% of the market value of shares allotted and any other amount paid. Subject to cap, there is a cap. 5% of market value of immovable property, or 0.7% of market value of shares allotted together with any other consideration paid, whichever is higher. So there is a cap, 5% or 0.7%. So, but still it is high because in other states it is lesser also. Now, there is a particular case which was dealt with. In this particular case, the judgment of High Court, there were two judgments, and the High Court, the judgment of the Bombay High Court in case of Reliance, they said that the Revenue Authority, they said that both orders, Gujarat High Court order and Bombay High Court order, because the property, the two companies were in two different states, both orders will be subjected to levy of stamp duty. So there was a problem. It has gone to Supreme Court, and Supreme Court has stayed the Bombay High Court order. Bombay High Court order confirmed this in favor of Chief Controlling Revenue Authority. In favor of authority, that means both orders are liable to stamp duty. This was challenged. In Supreme Court in 2016, the Supreme Court has stayed the Bombay High Court order. And now you will see in the Supreme Court, there were two orders. I mean, one staying the order, and then it is pending now. Final judgment is pending. In the Supreme Court, it was argued that on amalgamation, without the order of the High Court of Gujarat, which is later in point of time, see that's argument. This is a very creative, very intelligent argument. The document does not become an instrument so as to attract the stamp duty. What it says, that the Gujarat High Court order was later in time, and Bombay High Court was earlier in time. 7/6/2002, Bombay High Court, Gujarat High Court, 13/9/2002. In Supreme Court, it was argued by the company, Reliance, that on amalgamation, since both the court, to become effective, both the orders, when both the orders have been passed, then only it becomes an instrument. And it becomes an instrument as a whole. If any one order is in negative, rejecting the scheme, the other does not become an instrument. So both put together is an instrument. Plus, unless the second one also is passed, the first one does not become instrument. So you cannot levy the stamp duty on the first one. You levy stamp duty only in the second one, and both considered together. So with this ground, the Supreme Court has temporarily stayed in the year 2016, November 2016, and it is still pending for final judgment. So these are the considerations in the stamp duty, and I will request the host to take up the questions. I will be happy to answer any questions which arise.
Thank you, Krishna ji, for such a wonderful research and sharing with all of us. It's indeed a privilege, and it was excellent piece that we got in the morning to hear you out. We have got several questions. I will choose the good one from there, and I will request you to respond.
Yes.
Has asked, is it possible to go for merger where company is in liquidation as a failure of CIRP?
Yes, that liquidation merger in the sense that any scheme under 230 can be now made because of the amendment of the liquidation regulations, and so it is possible a liquidator or through the liquidator, other interested parties, they can make an application for a scheme under section 230, which can be merger also. It is open. So 230 is very open. The moment we come to 230, suddenly a vast vista gets opened and we can do anything. So yes, answer is in affirmative. Can you hear me?
Yes. Now I posted the queries on the screen itself.
Okay.
Ease out calling. The second question Bhumika has asked, can you please explain the difference between the organic and inorganic restructuring?
Okay. So this is a concept which is basically dealt with or discussed in the boardrooms. The law does not differentiate between any organic or inorganic restructuring. So, in case of there is no distinction between, in terms of the in the eyes of the law, there is no difference between organic or inorganic restructuring. It is only that when you are mutually you are taking up certain decisions or steps which mutually affect the parties, the company and the outsiders. So when they affect, and there are multiple such people whose interests, rights and liabilities will be affected, then you will have to come under section 230. If you are able to manage on one-on-one between the two parties, say a lender and the company, and mutually you agree for a lesser interest rate or cost something, but yes, it is possible outside the court without 230. So, yeah.
Akshita has asked, what is the difference between the takeover, acquisition and absorption? Although you have covered, I think, excellently in the session, you can just give one-liner what can be the key difference.
Takeover, acquisition and absorption. These are all overlapping also and different also. In some aspect, these are overlapping. Acquisition particularly is a very loose term. Takeover has certain definitions also. There is a separate regulation in case of a listed company to take over. In case of acquisition, some people, again, all these are management jargons, but which are helpful in evaluating the strategy behind in merger or whatever the restructuring. Acquisition can also be termed as just purchasing the shares and making the company as subsidiary or a wholly owned subsidiary. Absorption, yes, it is a term used in the accounting standards. So where the company is fully absorbed into another, well, this is absorption. But then no specific term is used in the Companies Act for the purpose of 230 scheme of compromise.
Krishnaji, Mansi want to understand the meaning of 9/10 in value. You say?
9/10 means 90% in value. So there can be, say, 100 creditors. I'm taking example of creditors because say 100 creditors, and they have say 100 rupees. The company has obligation of 100 rupees to them. Now it may so happen that one creditor itself has lent to you, or the company is under obligation to pay, say, 91 out of 191. So this exceeds 9/10 in value. So in value, so double majority rule, in number as well as in value, we have to say. In value means how much, the amount which the company owes to that person. That is the value.
Thank you. Bhumika is asking, sir, can you please explain the basic difference between application and petition?
There is no clear-cut difference between application and petition. In terms of a scheme, only it is expressly used that this is company application and this is company petition. So under 232, when we make the first motion, the section particularly uses the word company application, and when all the approvals of the shareholders have been obtained, it is called company petition. Apart from the scheme, apart from this, apart from 232, there is no clear-cut guidance about what is application and what is petition. Generally, when I am making a prayer where the determination of rights will have to be done is a petition. And generally, when we are not making any adjustment of rights and obligations of somebody, like say shifting of registered office earlier or compounding, all these are applications. So there are only thumb rules. There is no harm if you inadvertently used petition instead of application. There is no harm there.
Mandavi has responded perhaps to the Bhumika's query, and she is responding by saying that when you have to file a suit against any government authority, then you have to file a petition instead of application. Is that correct?
The moment against the word against comes, there is a mutual adjustment of rights and so it is petition.
Bhumika is again asking, sir, before entering into the compromise or arrangement, does the company enter into memorandum of understanding?
Advisable. But in any case, so there is no legal requirement. Legal requirement is only to draft a scheme. The scheme itself is MOU. But before that also, if you want to be abundantly clear, like how in joint ventures, term sheet we sign. Similarly, you can sign one term sheet or MOU so that at the time of drafting of the scheme, there is no problem, new aspects popping up.
Maya wants to understand, is there any upper limit for share capital of the company? I think it's general question.
Authorized capital and paid up capital, there are things. Paid up capital has upper limit, which is fixed by the authorized capital. Authorized capital does not have any upper limit. Why? Because the law does not want to come into the business wisdom of the companies. They want to leave the companies free and regulate only on those points which can deter, which are important mutually with respect to third parties. Then only.
Here's another question, but the solvency process takes time. Then how the fast track merger can be done? I believe her question is regarding the submission of a solvency certificate. She's confused with the process of the solvency and solvency certificate.
Declaration of solvency and insolvency.
Correct.
So, the declaration of solvency, if you want to go under fast track merger, declaration of solvency will not take time. You just have to approach your auditor and they will give one financial statements. Based on that, the directors have to sign declaration of solvency.
Very true. Mudit is asking, can two small companies opt for a normal merger instead of section 233 fast track process so as to bypass the 90% majority required as per double majority rule? I believe this you answered responding to the Dr. Hiral's question.
Yes.
Right, same question I had asked.
Rajeshwari has asked, please throw some light on possibility of demerger under section 233.
Yeah, subsection 12 or 233, it is possible to go for demerger. Initially, there was some confusion on this, that whether demerger is possible, but in my view, demerger is possible. And in Chennai RD, we have got quite a few demergers under section 233 also.
Yes, that's correct. It's very well possible. Mr. Hans wants to understand the concept of appointed date. Can we start the process immediately after passing the resolution by the members?
Can we possibly after passing the
Of question. First, we want to understand what is the concept of appointed date. Then regarding the process.
So appointed date, I guess before I could explain it fully, he would have raised this question. So appointed date, I explained in detail that what is appointed date, and with the help of judgments, I have explained. So can we start the second question? Can we start the process immediately after passing?
Yes, Krishna ji, this is a very early stage question. Session was on. I think you have dealt in detail. So
Yes.
question should be avoided. Shivani has asked, please discuss point of effective date of merger. Will it be date of order or date of ROC approval?
Yeah. So see, there is always this question: appointed date and effective date. So effective date, the earlier that confusion was not there in the erstwhile 394. It provided that the scheme will become effective only when the order has been filed with the ROC. It is not approval of ROC, filed with the ROC. So, but this particular thing is absent in the new section. So we have to go meticulously see the order of the NCLT, because by practice, the NCLT is writing in its order that to take effect, it shall be filed with the ROC. So this is something which you have to be careful.
Sir, Mudit is asking, he's giving a situation. I believe answer is simple. If A is a wholly owned subsidiary of B, which is a wholly owned subsidiary of C, which is a wholly owned subsidiary of D, or such a long chain, can merger of A and D be undertaken by fast track process of section 233 or not? So I believe the essentially question is whether A is a wholly owned subsidiary of D or not. That is what first of all we have to establish.
Yes. And yes, it is as per the definition of subsidiary companies, this will be considered as wholly owned subsidiary, and it can be taken up under 233.
There is an issue with 2013. We are only supposed to have 2 layers of subsidiary. We can't have a third layer also. So,
Yes, that has to be separately addressed by him. There can
Very rightly pointed out by Dr. Hidal. That's a restriction that has came in section 287 and also in section 186(1) regarding the investing companies. That's a separate.
yes.
Sandeep is asking, the books of accounts are also submitted to regulatory body. Destroying.
No, the books of accounts are not submitted to regulatory body. Books of accounts are retained by the transferee company. So there is, therefore, the company has to maintain it. So
I believe he is confused with the submission of documents and information and statutory record for the purpose of seeking and obtaining the report from the official liquidator. For limited purpose, you are submitting only limited last 5-year data, nothing else.
correct.
On obtaining the report.
Yes, rightly said.
Malini is asking, how does advising a company on merger acquisition practically happen? What are the aspects one will consider to enter into a deal? I believe it was dealt beautifully by Dr. Hiral also.
Yeah.
Then
Yes.
supplemented by Krishna ji, so we can leave because we have many other questions. Suparna has asked if the company is liquidated under IBC, preservation of record will also be under IBC?
Yes, we can say that. I particularly addressed this. In my view, yes, because IBC has non-obstante clause. So we can take shelter under IBC. So that we can destroy. So
another question from Suparna only. Yeah, what is the provision in US and Germany? If we can highlight, I believe it is regarding the preservation of record only.
Yeah, and there also the law is same. I'll just give my view on this. Law everywhere will almost be same in the sense of principles. The principles of law are same everywhere, be whichever country. Only the here and there the nitty-gritties will change, but the principles of law are same everywhere. So there will definitely be similar provisions, if not identical.
Kailash ji is asking if there is a demerger of B company from A company and the registered office of both the companies are at New Delhi. Is there stamp duty exemption at Delhi because of some judicial pronouncements?
That state stamp act will have to be looked into. I have not gone through the stamp act in New Delhi, but of course it is a conveyance because of the Supreme Court judgment in Hindustan Lever case. It is a conveyance, so there will be stamp duty. how much it will be, that rate has to be, for that you have to see the stamp act.
Shri Prasad is asking, can LLP merge into company or the reverse case? I think you have dealt beautifully and you have given the clarification also regarding your view also. Rajesh is asking, is there any restriction in usage of name of the transferor company got dissolved post amalgamation?
This time they have in the new act specifically provided. So 2 years limitation is there, but still you may insist and let the RD come back with objections. So you can propose the name, but you may have to amend it. Nowadays, since tribunal is under the MCA, tribunal does not want to go against the ministry's positions. Whereas when it was High Court was fully independent in applying its mind, and they used to lambast the departments also.
No, but Krishna ji, is there actually restriction? Because we have done several cases where the name of the transferor company has been used as a name of the transferee company post the scheme of amalgamation.
There is provision of
Part of the scheme only, not as a change later on, but as a part of the scheme itself.
Okay, so the provision under a name availability is that it will not be made available to others if it is if it is within 2 years of amalgamation of a company. Suppose Hindustan Lever Limited got merged, then I can use Hindustan Lever Limited after 2 years, but not before that. But then this is for any third party.
Correct.
Yes, for third party cannot use, but as part of the scheme, yes, transferor company.
Yes, that is where my point is.
Yes.
He is asking, kindly please explain how IBC redirects to Section 230 of Companies Act 2030, as IBC is route for rehabilitation scheme and 230 is the route for internal reconstruction.
So 230 is the window where all these restructuring can be done. Therefore, IBC redirects to Section 230 because essentially all the powers have been given under 230, and it has all the precedences, all the judgments in that. If a separate, so there is no necessity to carve out again one another window, especially for insolvent companies or companies under liquidation. There was no need. It will be futile to do that. So it is good that one window is available. Let us get directed to that. It is better, practical.
Rightly said so, and more so 230 is not restrictive. 230 is a very wide, which includes the compromise also. So when it directs, then it facilitates the corporate debtor to go for making a compromise with its creditor, basically. And
right.
It can be one, or maybe the other schemes can also be used very well. Sharan is again asking, supposedly one company in India merges with a company in Singapore. So who and where will the record be maintained?
So it is outbound merger.
Yes.
Merger with one in Singapore. So yes, this is something which will be maintained by the Singapore company, but then the Singapore company is not within the jurisdiction of NCLT. So the moment that merger happens, that goes out of the jurisdiction. So that is one tricky, one loophole available. Maybe people are very smart. They might use this also.
Yes. Compliments to the students and members who have applied their mind and they have asked such questions.
Very good. This is, I should appreciate. This is a very good question.
Then she's asking, what are the points to be considered while takeover of a partnership formed by a company? I believe this is not covered in 230 or 231, 232, 233. This is separate takeover, but still, you may please give your views.
So it is just the business.
Yes.
Because why will a partnership firm be taken over by a company? It is only the business. And what are the assets under the partnership firm? Who are the clients of the partnership firm?
Business, you either pay the consideration in cash or maybe by way of issue of shares.
shares. So you can issue shares to the partners. That's all.
Shant is asking, are there any form of corporate restructuring other than amalgamation and merger? I believe this is also dealt in detail. Jaideep is asking, can books of accounts be digitized and physical records be destroyed?
Well, there are difficulties in this. It can be definitely digitized and maintained, but I will not advise destruction of physical records.
Clarification has not come from the ministry, so maybe once you destroy, the difficulty may arise tomorrow. So
Yes.
advisable not to destroy. Sushmita is asking how to protect companies from hostile takeovers.
So there are, again, this is a boardroom discussion.
I think, this is again only academic question because in India we don't see any hostile takeovers at all.
There is one concept of poisoning the company. So there is in that book of Shri N.R. Sridharan and Arvind Pandian, they have we have discussed this, and poisoning the company is one way to prevent the company from getting taken over.
Maji is asking liquidation state under insolvency. Does it mean formation of a trust? What actually is done to form a liquidation state?
But no. Liquidation estate doesn't mean formation of a trust. It is merely a list of assets of the company which is under liquidation. So estate is a term which is used to depict assets and liabilities. So it is estate here means the list of assets and liabilities of the company which is undergoing liquidation.
No conveyance take place. The ownership remains with the corporate debtor only. It's only that he is provided with certain rights to dispose it off for the beneficial liquidation of their stakeholders. Ayush is asking, as you have pointed out in the Bombay judgment of Justice Chandrachud, how far have we come to reduce the scope of courts in commercial matter and central government intervention? I think this is relevant. Khushbu is asking, can shareholders or creditor request for waiver to call meetings by giving consent with more than 90% in value and majority in numbers too in case of a fast track merger under section 33? Yes,
that is exactly what is visualized.
Ayush is asking, is the principle of lifting of corporate will can be an exception to the deemed bona fide intention of the majority shareholder?
Yes, it was that in Mihir H. Mafatlal case itself, they have cited Hanbinson case in which the not corporate veil, but the veil of the scheme was lifted. So here, what will work is not the corporate veil; it is the veil of the scheme. So it can be lifted. Yes.
Surbi is asking, can CDR under 230 be an alternative to creditors? For the time being, IBC is suspended. Will it be beneficial for creditors?
It has to be evaluated. Yes, they can go under CDR, and CDR, there are CDR regulations by RBI.
Certainly can be explored.
Yes.
If the records are not available with the transferor company for the genuine reasons, will it be considered in the process of amalgamation?
In the process of amalgamation, the company which is the transferor company, that is going to get dissolved. Therefore, the official liquidator will look into the records of that company. Normally, they don't go beyond 3 years, 4 years, or 5 years max. So, if the records are not there for more than 5 years, it may not become impediment in completing the process of amalgamation. But in case later after merger, what happened in Dalmia Jain case, if the regulator comes later and says that you show me the documents, you are under obligation, legal obligation to show the documents. So for genuine reasons, if the documents are not available, that cannot become excuse. If the reasons are genuine, then there should have been genuine steps like filing of FIR or those things. So you should have taken it on.
Shri Prasad ji has asked one question, but I believe the matter is sub judice before NCLAT. It is not better to comment on that. Jaideep is asking one question on creeping acquisition and slump sale.
Okay, so creeping acquisition is something slowly you keep purchasing the shares from stock market, which is regulated by Takeover Code. So essentially, this concept is applicable to listed companies. Slump sale is kind of divesting, cutting off one unit of the company and selling it to another. That is slump sale all put together. It can be done by way of a demerger, or it can be done by way of normal provisions under the Companies Act.
Company if resolution professional liquidate company under insolvency. When they cannot acquire, they can acquire. What will be the case if promoter are willful defaulter? Case law. I believe essentially the question is the person who is barred under 29A
Correct.
of IBC, can he acquire the assets? Answer is no. I think there are several judgments. What are the key points to be considered for the takeover of a partnership firm? Same like a proprietorship firm, will not take this question. Can promoters acquire company if resolution professional liquidate company under insolvency? This is again same question. Is it not a good idea if either of the company's registered office is changed and a joint application for a merger or amalgamation is filed? I believe this is a repeated question where the registered office are situated in a separate state. So he's suggesting can we shift the registered office first and then move the joint petition? Yes, certainly it is a good idea. Depending on time and feasibility, you need to explore. Akanksha is asking, are all these provisions only applicable in the case of merger amalgamation? What happens to the case of acquisition? Are there any separate provisions in the Act regarding the same?
Acquisition is purchase of shares. To one limited, in limited way, acquisition is purchase of shares. The moment you do merger, you are doing merger. If you are not doing merger but still acquiring control, it can be done only by way of purchasing the shares. So normal transfer of shares and all will happen. If it is a listed company, there are additional consequences.
Yeah, just a small point that I want to add is the recently government has notified the provisions of section 230(12) also, whereby the squeezing of minority by way of acquisition is also possible by filing the scheme. I believe that may help and address your question. Shalini is asking, please let us know in case of merger of wholly owned subsidiary company with a holding company, time-wise RD is faster or NCLT?
So I always feel comfortable going with NCLT. So, well, RD may be faster.
Theoretically, time is certainly less in 233. Rest is you have to understand and evaluate your own case, and then you will be able to decide. Alok is asking if the order passed by tribunal for merger reconstruction has to be filed with ROC to give effect the same. So if tribunal does not resign the order, then will that be effective?
So it is a repeated question in different words. There is no such provision that it should be effective only upon filing. That express provision has gone now. So we have to be careful about the order.
I believe we have taken all the questions and you have patiently replied to all the doubts. We have exceeded the time by almost 24 minutes. I extend my all thanks and gratitude to you for sparing all your time and coming to this discussion. And it was indeed a very wonderful and enlightenment discussion that you made, sharing all your research that you have done by finding out so many case laws. Such a detailed deliberation you had made. Now I'll request Hiral ma'am is there, so she can give her concluding remark and then.
Thank you very much, Krishna. Very enriching experience for everyone, and that's very evident from the comments also that we're getting. It's really nice, and the detailed research and the points that you have made out. Like you started with the existing legal provisions that deal with section 230, 232, and also dealt with the old act, section 391, 394. Then two stages of mergers, the application stage and then the company petition stage, which is also a question, the first motion and the second motion. He detailed out how if the company fails to make an application, the creditors can pursue it with the leave of the court. And then he talks about the tribunal, what the tribunal looks for during the first stage of the motion. The tribunal will inquire regarding the type of scheme, whether the amalgamation in nature is in nature of purchase, what will be the effect of earning per share, the swap ratios. Then Sir dwells into the procedure for classification of members, stating that it does not follow set procedural standard procedure and displays variance. An interesting question can whether buyback can be permitted in a scheme of merger, and there he also discussed SEBI versus Sterlite Industries, and finally, of course, made his point that it can be permitted, and similar is the case of reduction of capital as part of the scheme under Section 230. So then addresses the queries regarding applicability of Section 188 of the Companies Act with related party transactions. And then he explains about fast track mergers, Section 233, and what are called about the holding and the wholly owned subsidiary. He then highlighted the importance of preserving the books of accounts and comparative perspective with the practice in other jurisdictions such as Singapore, UK, etc. Then he came down to cross-border mergers and mergers, outbound mergers, and the permissions of RBI that are required for that. He also discussed mergers of private banks, which is also even regulated by the Banking Regulation Act. Then Sir moved on to landmark judgments under the acquisitions. And in fact, I think that was very insightful, especially for the law students. And he also discussed in detail he calls the Lodge bench judgment, which is Neeraj Mafatlal versus Mafatlal Industries Limited, and has discussed in detail all these judgments, patiently answered all the questions that have been put up. I think answering so many questions itself is an art. So thank you so much, sir. I think I have really benefited a lot from this session.
I will request Dr. Vishalakshi to say a few words so we can close.
Practical point of view. Today's class is exhaustive. Thank you, Madam Herla Mehta, for your valuable contribution to the program in the form of thought-provoking introduction. Thank you. Thank you.
My pleasure to be here. Thank you.
Thank you to all the esteemed panelists for being here. And one small announcement for tomorrow's session. Tomorrow is going to be another very important session and very important aspect we are going to cover, that is a related party transaction, which is considered to be one of the most complex areas that keeps on troubling to most of the students of the law and the professional. And we have a very eminent faculty from DLF Limited, Mr. Pankaj Karmani, General Manager, Corporate Secretarial, will be with us to guide us and teach us how the approach should be there for the undertaking the related party transaction. See you tomorrow morning at 7 a.m. Have a good day. Till then, thank you so much.
Thank you.
Thank you. Thank you.